Yes.
Can I make a mention?
Item number 1,
Yes.
they are not fitting well.
No issue. No, in fact, I am not. It's a fresh matter. But how is it 2021?
No, test no, it is final diploma. Test the heading there. I have also filed my counter.
Oh,
Only
Somehow
connected case, no.
Huh?
Connected case. Not first one. That is second one, 16897.
again 2021 matter.
Yes.
So how do you say that they are fresh matters?
I'm not reopening the account.
In the first matter, you are appearing.
No, first matter I'm appeal.
No, upon second matter. Mr. Nanda, you are appearing.
No.
You are not appearing.
My lord, I will appear in first matter, my lord. My lord, I am appearing in this case, first matter.
What? Mr. B.K. Padhi for the petition. Mr. 1, who is appearing? Mr. Sanjeev showing AGA for the state. 33700 of 2021. On consent list of Ms. Mahapatra suggested date.
मेरे जून में जो कौन छोटे डेट
24-25
आज्ञा जब भी रखो
24 रही
24/6/2025 is submitted by the learned counsel for the appearing parties. Item 1, you are not.
No, my lord, it is a fresh.
It is. Mr. Padhi, your matter is also a fresh matter.
My lord, I am not remove the defect, my lord. So in this regard, I will pray for time.
Is this?
नहीं सेटा कौन पे फाइल करते हैं इनफॉक्चर से जाइन तो
whether that is connected or not.
Next statement.
Journalist.
No, my lord.
हाँ
My lord, I will pray for time.
आज्ञा
24. Second matter, Mr. P.K. Nanda for the petitioner.
opposite part number 8 I am appeal.
Mr. Sajid Pai AGA for the state.
I am for opposite part number
58, Ms. Dipali Mahapatra. On consent distance 24/6, it is submitted by learned counsel for the appearing parties that the matter, the pleadings are complete
आज्ञा
in the matter, and the matter is to be. Here, who is filing this? How very good, Chun. All like that. And the matter to be listed for admission.
आज्ञा
Or after notice admission.
Under the heading of fresh admission, that can be decided.
How can you take fresh after notice and the fresh admission?
No, first one that was
The
not.
Mr. Padhi doesn't know what has happened. He says he might have. He doesn't. Maybe he's lost a file also.
मैं बाबूजी से आगे हमारा इनफॉक्चर से
No, my lord, I have filed, my lord, but some defect is there. So
also, Mr. Padhi is surrounded by fog. Fog or mist, something like that. He says. Mr. Saubhagya Kumar Ratha has submitted that he shall file Wakalatnama on behalf of the OP 4, 6, and 7. The Wakalatnamas shall be taken on record. A scanned copy of the brief shall be updated. Name of Mr. Ratha shall be indicated in the cause list as well as the case brief.
My lord, item 30.
Interim order.
Directed.
Just again. Sub item 16897 interim order to continue.
नहीं सब आइटम 1 रे नहीं एटा फ्रेश एडमिशन डिफेक्ट रे पर्यंत केनी सब आइटम 2 रे इंट्री ऑर्डर
हाँ माने 16897 16897 जो बिल्डिंग्स अछि सेटा रे
आगे
Item 30.
yes
30. Personal appearance was directed. Remember that I am appearing for the bank. The officer is here.
you wait he'll be called.
Item 2.
My lord
Item 2 Mr. K.K. Mahapatra for the petitioner, Mr. Sanjeev Pai AGA for the state. Next के ऐसे में बस में dictation लगती है.
my lord
ठीक है गोटे one after another because I'm not keeping the matters for latter to be dictated. K.K. Mahapatra, yes, what do you want, Mr. Mahapatra?
The Lord sir, I kindly taken package.
Yes, what date कर दियो तो?
And the sir.
Counsel for the petitioner 6 adjournment आज प्रेट for list on 8 साथे ठीक अछि? 8 साथे 2025. Yes.
Deep
My lord, item number.
Mr. Baral, you are mentioning 3.
No, I'm
Okay. So those who are not mentioning, please kindly take your seat.
My lord,
Yes.
item number 789 on behalf of Mr. Kedar Kumar Das, kindly
Sir, what is your name, sir?
H. Samal. On
You
behalf,
have power.
no,
Mr. H 789.
789 item number.
Item 789. Honorable Order. Mr. Kedar Kumar
Das.
Mr. H Mahapatra.
H. Samal.
Mr. H Samal on behalf of KK Das for the petitioner. 789. Mr.
Mr. Swai, 8-9.
7 Mr. Sanjit Swai AGA for the state. 8-9 Mr. Devaraj Mahanti AGA for the state. Learned counsel for the petitioner. 8 7 7. 7
My lord, item 20.
Put a second. Let me complete. I am dictating the orders
My lord.
as it the matter it is being mentioned. The learned counsel for the petitioner. 6 adjournment as prayed for lister. 10 Yes, 10
Item 7, my lord.
Item 7.
I have instruction to appear.
Begin senior counsel submits that.
OP number 2.
The learned associate has been instructed to appear for OP number 2.
Managing Director, Corporation. Petition State Civil Supply Corporation.
OP number 2. 2 and 3. AGA होचंती 1 and 4.
Sir.
2 and 3. P6 for he submits that the Wakalatnama of the learned associate and his appearance memo shall be filed within today. It is being filed today. Stop the same shall be taken on record. Name of Mr. Sharma along with learned associate shall be name of Mr. Sharma learned senior counsel along with his associates shall be mentioned in the cause list as well as the case brief.
Item
Let us go one by one. 8. Same. 8 Samal, madam. 8 Samal. 8 Samal on behalf of KK Das for the petitioner. Mr. Devaraj Mahanti AG for the opposite parties 1 and 4. Mr. J. Pradhan. Mr. Samir Kumar Misra, senior advocate, along with Mr. J. Pradhan, advocate for OP number 2 and 3. The learned counsel for the petitioner 6 adjournment as prayed for same date. 10 Item 9.
Yes, also.
Appearing, Mr. Pradhan, you are appearing or Mr.
9 I am appearing.
9 same as 7.
2 and 3 I am appearing.
Yes.
Same as item number 7.
7. Yes.
Obliged, my lord.
Yes, the page 2 back on to item 7 to 17.
Item page 2, item
10 to 17.
10 to 17.
Next. Page 3, item 18 to 23.
Item 22. Item number 24 and 25
Sir.
may
Sir,
be fallen
Sir,
sometime after
24,
vacation.
25, sir, next page. Just a second. Item page 3, item kete kahle?
Item
Mr. Subhanti?
22 University. University was appearing for the opposite party University. University.
Mr. Acharya is there.
I already informed University.
Mr. Ramanath Acharya for the petitioner. Item 22 lecture. Mr. Somnath Mishra along with Mr. J. Mahanti for the opposite party. The learned counsel for the opposite party 6 adjournment to obtain instruction. Then after notice.
Well, after instruction.
To obtain instruction. He submits that he has also informed the learned counsel for the petitioner. List on
14.
14
Well,
for OP1, who is appearing? Regional Provident Fund Commissioner.
Only APF.
RPF, EPF to no. Employees Provident Fund no है.
RPFs.
For 2 and 3 में
My lord.
Mr. Somnath Mishra for OP 2 and 3.
Aye.
ଆପଣ RPF ପାଇଁ ନା ଫରେଷ୍ଟ ଡେଭଲପ କର୍ପୋରେସନ ପାଇଁ?
OFDC.
OFDC 2-3. Item 22, 2-3. Item 24-25, Mr. Mishra.
Sir, maybe call her after vacation. This for final disposal. I'm not well. I'm not.
Civil Supply Corporation, anyone appearing? 24-25.
24-25. I could not file also the rejoinder. I will find out whether.
Mr. H.S. Mishra for the petitioner. Mr. 24, Mr. Why, Mr. Manti? They debe apan thale.
24 Anshuman Sethi.
Mr. Anshuman Sethi, Additional Standing Counsel for OP1. Mr. Samir Mishra, Senior Advocate, along with Mr. J. Pradhan for OP number 2 and 3. I think the allotted counsel for the petitioner submits that matter may be urgent and liberty may be granted to file rejoinder. On consent list on 15/7.
Yes, ma'am.
25 also you'll file rejoinder.
Yes, 25 also.
25 same order.
Same.
My lord, item 27.
Item 26 to 29.
27, my lord.
Yes.
29 also.
No. 26 ଆପଣ କହିଲେ sorry.
27 and 29.
ଗୋଟେ ନମ୍ବରରେ ଠିକରେ ଶୁଭିଲାନି. 27 and 29.
My lord.
27, Mr. Somnath Mishra, along with Mr. J. Mahanti for the petitioner, Mr. A.P. Rai for the opposite party. You are appearing for all, Mr. Rai?
My lord.
Mr. Rai? Mr. Mishra? Joseph Mahanti. Yes. Yes, what do you want, Mr. Rai?
After vacation.
On consent list on? 16/7. Interim order passed earlier. Interim order dated so and so shall continue till the next date of hearing. Yes.
29, same, my lord.
26 वाला है
27, my lord.
27 वाला ठीक है
29.
26
29, I'm appealing for OP number 4.
29 who is for the petitioner? You are अपन का नाम है SS Maharana. Mr. SS Maharana for the petitioner. Mr. P.B. Balakrishna for the opposite party. 29 elected.
Instruction to appear for opposite party number 5, ICICI Bank.
Just a second. I'm getting the file.
1, 2, 3, 7. Yes, I see.
For ESI, Mr. Balakrishna, you are appearing for all.
Yeah, I'm
No, for yes, I say myself, my lord. 1 to 3, my lord.
ଆପଣ ନା କିନ୍ତୁ ନାହିଁ ସବୁଠି ଆପଣ ଏଣ୍ଟାୟାର ଲିଷ୍ଟ ଆପଣଙ୍କ ନାଁ ରହିଛି ଫାଇଲ କରିନେ ପାୱାର ଫାଇଲ କରିନେ
ନା ଫାଇଲ କରିନି
ଦିସ୍ ଇଜ ଆପେଣ୍ଡିକ୍ସ ମ୍ୟାଟର ଠିକ ଅଛି Mr. Balakrishna, you are appearing for the bank, State Bank.
only statement.
You are for the ICICI Bank. लिखिए Mr. SS Maharana, Mr. Satyasmruti Mahanti, along with SS Maharana for the petitioner. Mr. P.B. Balakrishna for OP4. ଆପଣଙ୍କର
Nalini Kanta Das.
ଆପଣଙ୍କ ନାଁ
B. Pooja.
Miss B. Pooja on behalf of N.K. Das for the OP number 5. It is submitted by Mr. Ray, Amarendra Prasad Ray, that he has instructions to appear on behalf of the opposite parties 1, 2, 3, 1, 2, 3. Keep a file koribe. How much time to file wakalatnama? 1 week.
my lord.
He seeks 1 week. He submits that he may be granted time to file wakalatnama. Okay. Stop. Wakalatnama be filed within 7 working days.
My lord.
7 working days. Name of Mr. Ray. Upon filing of wakalatnama, upon file करचंदी.
Should by Monday.
You should have said. I thought that take same order for N.K. Kanta Das. Like Miss Pooja, Mr. Ray and Miss Pooja. And at council submit that. They shall file their wakalatnama. Time kono condition to file work 7 working days. Name of Mr. Ray shall be reflected in the Mr. Ray and associates for OP number 1, 2, and 3. Mr. N.K. Das and associates for OP number 5 shall be mentioned in the cause list as well as the case brief. Date 16/7
Lordship, interim order
Interim order
to continue.
dated so and so shall continue till the next date of hearing.
Item 5 on behalf of Mr. Suraj Mal. Item 5.
See, Dr. Peter more money achi. The adjournment bhi money achi. I will pass that order. I have some difficulty in forgetting actually. That is the problem. And when you try to pass time and after 7 days or 7 months, you re-argue the matter. So there have become actually the counsel actually. That's the difficulty in Mr. Mahanti's matter. I have been advising him so many things. Do this, do that, file IA, file petition, the scope of mandamus to direct or the other side. No difficult.
Exactly.
I don't know.
The entire bar is there to get adjournment. You can do. So how could you know that you will mention item 29 or made you outside? So you have to be careful when somebody mentioning 29 also mentions item 1. Then the inference is that the lawyer is outside. Getting government counsel is safe because they remain present throughout the day. Or say item 1 like Mr. Patnaik is mentioning.
No, I don't know 30.
Mr. Acharya is mentioning. No. It is marked for personal appearance.
Oh, yes.
It will be. Yes, item like Mr. Acharya?
30.
30, Mr. Subhasis Patnaik for the petitioner.
The officer is here.
No, he's not invited. The court doesn't like anyone's presence. The officer has outgrown his shoes. He refuses at lawyer's notice. That's a matter of concern. And that too, the lawyer says that he is waiting from High Court. So why the officer, his place is to sit in the, in his room in the bank and do his official work. And perhaps much more important work is that to attend any court's notice.
Yes,
when they are having in the public interface.
A little confusion, so unintentional. I am appearing now for the bank.
No, I don't know, Mr. Patnaik would have confused, but the court's order is very clear. Court's order is very clear that, and the unnecessary, you see now Mr. Swine is involved. He has to be told that he will utilize his office. The power of coercion is with the state. Monopoly of coercion.
Where is he? Where is he? Has he come?
Modern state.
Where is he? Has he come?
Yes,
Where is he?
he is there. I'm representing the bank, filing my vacancy number.
Can't see him.
He is there.
Where?
Don't raise your hand. Don't raise it. This is not a classroom, sir.
We have to teach a
Keep
lesson.
smiling, but don't convert it into a classroom. This is a serious courtroom.
अपना notice क्या receive कर लेंगे?
सर एक्चुअली देयर इज अ कंफ्यूजन बट जो स्टाफ लेके आए थे वो बोले थे ये मतलब एडवोकेट का लेटर है, कोई नोटिस नहीं बोले थे। और वो
अरे आपको पढ़ना नहीं आता है क्या?
नहीं, वो मतलब दिखाने से पहले ही।
तो आपको कैसे पता चला वो एडवोकेट का है या नहीं है? क्या है?
नो, दैट वाज माय मिस्टेक दैट
so don't. You are not supposed to, maybe a mistake or you are apologetic, but that is not relevant. You see, the court's time is also precious. Your time is much more precious. Perhaps the work you have been assigned also. Why should you come here and spend time? You do not have a responsibility for your work.
Yes, sir.
So you must understand. You could have asked Mr. Acharya what is Dasti. Suppose you maybe are you a law student or a law graduate?
No,
I was not aware.
Or even law students may not know the exact procedural aspect. The matter is taken up on mention as being mentioned by Mr. Acharya. Mr. Panigrahi, I'm so sorry. Mr. Panigrahi, Ramachandra Panigrahi, appearing for the opposite party number 2. Whoever is there. Mr. Swine on an AGA submits that pursuant to the order dated 14/5/2025, he had informed the concerned DCP
Yes.
DCP, who in turn utilized his offices, utilized his personnel to ensure presence of OP number 2 branch manager, ICICI Bank, Sriya Taki Square, Bhubaneswar. Mr. Panigrahi submits that the branch manager is present and being identified by him. What's your name, sir?
Saras Kumar Patnaik.
Saras Kumar.
Yes.
The branch manager submits that states that his name is Saras Kumar Patnaik. There was some confusion in understanding the letter sent by the lawyer as per the Dusty notice issued by order dated 12/5/2025. You are so happy or apologetic?
No, my mistake.
He tenders apology for the for his conduct in not responding to the court's notice being served through a lawyer as directed by the court. So, personal appearance of the branch OP number 2 branch manager so and so is dispensed with. Yes. Yes, you can see.
Thank you, sir.
Your Lordship, item number
I'm
13.
obliged that he's thanking me.
Now, my letter.
Court of counsel. You should consult a lawyer.
It's
Yeah,
message for all of.
Eh?
Message for all. This should respect the.
No. I don't want to send messages. Messages are sent to me, Mr. Panigrahi, Mr. Swai, Mr. Patnaik. I have come to this side. But definitely I try to, but still it is very difficult to become not to leave that role of a lawyer. Yes. Anyway.
Your Lordship, item number 13.
No, what is 30? 30 showroom mentioned. Personal appearance are usually marked and taken up. Shall be taken on record. Scanned copy of the brief shall be updated. Yes.
I'll short copy on him in course of day tomorrow.
So ଆପଣଙ୍କର entry order କଣ ହବାର ଥିଲା କଣ
ଏଟା ଖାଲି ସେଇ ଟଙ୍କା ବ୍ୟାଙ୍କ ରେ ରଖି ବାକି ଟଙ୍କାଟା ଆଲାଉ କରିଦେଲେ ଆମର ହେଇଯିବ ପର୍ପସ୍
ବାକି ଟଙ୍କା ନାହିଁ. The total amount in the bank is 5,90,000. 283 rupees 54 paisa only. All three accounts.
Okay. All three accounts. The next question is, can the bank guarantee be enforced in such a situation? What is your instruction? Because being a banker, your officer can advise you. Suppose they furnish a bank guarantee, can it be enforced? Bank guarantee to the creditor of this proceeding before the court.
Because this was released based the order of the radian certificate.
Correct.
If they are okay with the bank guarantee, bank is nothing to object that.
No, that can be modified. That's not the question. Who is
the amount is very less amount.
Whether the bank guarantee can be enforced is the question. Short question is bank guarantee. You come back.
When the bank guarantee furnished to the requirement.
Bank guarantee will be enforced in the eventuality by the certificate officer, not by the bank.
No, no. Still, I have not gone through the question. And I am not unable to clear. Suppose the writ petition is allowed or disposed of or dismissed. In case of dismissal of the writ petition, the certificate officer will enforce this amount certificate due. In that scenario, whether the amount can be enforced by the interim order of the court, that there I am seeking your assistance. And in fact, Mr. Patnaik was asking me to say a little bit in a different way. So how to go about it? Because it's interim protection.
Interim protection to this is what I have gone through that order first.
Suppose I will furnish bank
marking that much amount.
Correct.
Real. If something excess to the 52 lakhs is there,
correct,
the account will be operational and he is free to take it. That was the interim.
Right.
But today the amount is much less in the account. So there is no question of defreezing. That's the freezing amount is 52.
So Mr. Patnaik, I have understood that it cannot happen today. So you have to furnish. So
reopening week, Lordship, may kindly pick it.
The one like that.
4 কোটি কত
The learned counsel for the bank on being asked submits that the total amount is remaining in the three accounts as referred to by the petitioner in his petition is rupees
5,90,000
5,90,
283 0.54. Right. As on 15/5.
As per the instructions received from the bank. OP number 2.
As on 15/5/2025.
Date is 15/5. That is the balance on 15/5/2025. The learned AG submits that the certificate dues as enforced by the OP number. अच्छा certificate option party करना है अच्छा question. I know OP number 1. The demand is 52, whatever 52, 15, 332.
It will be again interest will be added.
To that interest will be added. The learned counsel for the petitioner seeks adjournment to obtain instruction regarding securing the amount for defreezing the bank accounts. The learned counsel for the petitioner. Yes. As prayed for list term,
reopening week, right?
Mr. 25 Yes. Yes, please.
Item 3.
The Bharat. Bharat for the. Yes, please.
Annexure 1, running page 12, is put here.
Yes.
It is letter issued by the certificate officer, Sodar Factor, imposing penalty and multiplying on the fine amount imposed by the RTI commissioner. My lord, in this case, my lord, one Baghampur Patnaik seeks for information to the Department Panchayat Raj, in which the petitioner was working. The information was given him. It is late within 60 days, not 30 days. First information at the application, then first appeal. Just during the pendency of second appeal, the information given to him. But the commissioner imposed fine amount, which is challenged before the Hon'Ble Court, and the Hon'Ble Court grants stay order. Thereafter, the case listed in the 2023, my lord, the Hon'Ble Court directed me to withdraw the application or pay the fine amount. So that I withdraw the amount and file an application before the authority, certificate officer. So I will pay the only fine amount. Because during the pendency of the suit and stay order, I will not.
Because you challenged it. So the point is that you challenged the order, so that is how you did not pay it.
It's the interest amount. Out of the 2008, immediately we have in before the Hon'Ble High Court in the writ application stay order is granted, and they have no capacity to write the application letter to the certificate officer to initiate certificate proceeding. That is the my lord my grievance.
Certificate proceeding, there is no provision in the Right to Information Act.
Pending status
কিন্তু ଆପଣ ଯଦି certificate ଯଦି ଗୋଟେ due ହେଲା
ଆଜ୍ଞା
ତାହେଲେ how they will collect it?
ସାର୍ଟିଫିକେଟ କରିପାରିବେ ଯେ ଆମର ଷ୍ଟେ ଅର୍ଡର ଥିଲା ସେମାନେ କରିବା କଥା ନୁହଁ, ମାନେ ସାର୍ଟିଫିକେଟ ଯୋଉ ଦିନ ପଠେଇବେ ସେଦିନଟା ଆମେ ଇଣ୍ଟରେଷ୍ଟ
ଥିଲା 16/5/23 ପର୍ଯ୍ୟନ୍ତ ଥିଲା।
ଆଜ୍ଞା
ବଟ୍ ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି withdraw କଲା ବେଳେ ଆପଣ
ସେତେବେଳେ ଲେଖା ହେଲା
ଲିବର୍ଟ ମାନେ ଆପଣଙ୍କ ଡାଇରେକ୍ସନ ଥିଲା ଯେ ଆପଣ ଖାଲି ଦେବେ ଫାଇନ୍ ଆମାଉଣ୍ଟ ଇଣ୍ଟରେଷ୍ଟ ଦେବେନି
ନା ସେଟା
କୋଉଠି ଅଛି ସେଟା 1/5 ମୁଁ ଦେଖିଲି ଯେ ପାଇଲି ପେଜ 1/5
interim order dated 31st July 2000 passed in this case it stands vacated.
ସେଥିରେ ସେଇଟା ହିଁ ରେଫର କରୁଛି ବଟ୍ ଆପଣଙ୍କର ଅର୍ଡରରେ କିଛି ନାହିଁ ଯେ ଆପଣ ଖାଲି ଆମାଉଣ୍ଟ ଟା ଦେବେ ସେଟା ଦେବେନି।
ଆମର ଆମାଉଣ୍ଟ ଯାହା ହେଲା 2008 ପର୍ଯ୍ୟନ୍ତ ଆମେ ଟଙ୍କା ଯେତିକି ଟଙ୍କା ଥିଲା ସେ ଦେଇଦେବୁ ଫାଇନ୍ ଆମାଉଣ୍ଟ ଟା ଦେଇଦେବୁ। 8 ଠୁ ଆଡ଼ିକି ଯୋଉ ପେନାଲ୍ଟି ଆମାଉଣ୍ଟ କରିଛନ୍ତି ମାଇଲର ଦେଖିବେ ଏଥର 3 times 4 times ଏମିତି ହେଇଯାଇଛି। ଏତେ ଟଙ୍କା ଗୋଟେ ମାଇଲର that is another provision at the act, the fine amount should not be more than 25,000 25,000 ଭିତରେ ଯାହା ଆମାଉଣ୍ଟ ସେ ଦବ। ସେଠି 5ଟା କେସ୍ ସେ ଗୋଟିଏ ଇନଫର୍ମେସନ ସେ 5 ପ୍ରକାରରେ ମାଗିଛି, 5ଟା କେସରେ ମିଶେଇଲା ବେଳକୁ ତାର ବହୁତ ଟଙ୍କା ହେଇଯାଉଛି ଦବା। ତେଣୁ ମୁଁ I am ready to deposit the only fine amount imposed on me by the RTA Commission.
ଆପଣ ଦେଇନାହାନ୍ତି
ଦରଖାସ୍ତ ଦେଇଥିବେ, ଦରଖାସ୍ତ ଇଣ୍ଟରେଷ୍ଟ ମିଶିକି କେତିକି ଟଙ୍କା ଦବା କଣ
ଦରଖାସ୍ତ
my ଦରଖାସ୍ତ my application is
ପେଜ 12
my lord my application is page 17 my application. After obtaining the certificate copy of the order of the Hon'Ble High Court, I submitted the application. I mentioned this court order ହେଲା ଗଭର୍ଣ୍ଣମେଣ୍ଟ ବି ଥିଲେ ସେ କହିଲେ
but fine amount application can it be made to the sub collector being a certificate officer?
ସେ ତ certificate notice हम ଦେଇସାରେ
because he cannot go behind the certificate the order issued by the commissioner.
Commissioner order ଦବାକୁ ଆମେ ରାଜି ଅଛୁ, commissioner ଯୋଉ ଫାଇନ୍ ଦେଇଛି
that's not the question. Annexure 3 is a letter to the sub collector certificate officer.
My lord,
certificate officer is simply proceeding to collect the amount intimated by the authority.
My lord,
so have you intimated the authority?
Authority certificate then my lord
yes, Mr. Das, you are appearing for the information commission.
Yes, for the
See, for a government servant, this is very harsh. He doesn't have any I mean you must understand honesty of purpose. That's a word called honesty of purpose. He's doing his government job. You cannot attribute that he deliberately did not do this or deliberately did this.
Penalty is maximum penalty 25,000.
He has to pay from his pocket.
Kindly see, my lord. There is a rule, Odisha Right to Information rules. If that person is not providing that penalty amount,
person is government information you are seeking. So that is a is he disputing that there is no rule? So no, that's why should you argue that? The question is when you are trying to collect from a retired government employee in his official capacity, he did something. And ultimately, are you saying that the information was not provided?
Though the information was not provided, delay in supplying the information.
Ultimately, whether the information is provided or not.
That has to be seen, my lord. And the copy has not been sent to me.
No. Then you obtain instruction, then let there be stay.
My lord.
The other difficult part is that Mr. Das.
My lord.
There was a first appeal.
First appeal.
Your application, the person's application was rejected.
Not rejected, my lord.
Then why first appeal? If the information application is not rejected by the RTA officer,
my lord,
PIO, public information officer, then why the first appeal was filed?
First appeal is 2 grounds, my lord.
First appeal who filed? You filed the person seeking information. Obviously. So that is apparent. So then you are also frustrating the statute itself. Then first of all there is a rejection. The rejection order is challenged. Then first appellate order. First appeal is filed. During pendency of the first appeal, the information is provided.
That has to be seen, my lord. I have not.
Then Mr. Bande Baral for the petitioner.
May I submit, my lord?
Yes, Mr. Swan.
So his entire case is he don't want to pay the interest. So let him pay the principal amount. Interest may be stayed.
Otherwise also, apart from the legality of the whole procedure has to be considered. Because there is
No, he is now ready to
even,
pay.
even if he forgoes his right. So the officer, any authority cannot act arbitrarily. Like Silabar said, the PIL cannot be withdrawn. Why? Because arbitrary action of the authority, suppose the authority is charging the interest for the period from when it was rejected, when it was first appellate authority rejected it, or we withdrew the after he provided, then the first appeal was rendered infructuous, if I have understood correctly.
That he has filed in the earlier case that has been withdrawn.
Correct.
After withdrawing, the only certificate case is the alternative. Now in the certificate case, he is ready to pay the principal amount, but the only question is whether he will pay the interest or not. If there is any waiver provision, that can be considered by the
other difficulty is that the certificate case, he has approached the certificate of
no, that is what I am telling. We'll take instruction from the concerned requisitioning the certificate.
I don't think he has power. The certificate officer cannot go.
No, certificate officer will not consider.
Certificate officer, the application at page 17.
Yes, certificate officer will not do it. Commission.
Commission, Mr. Das, you are appearing or
Commission, I am appearing, my lord. Commission has no power to waive out this interest.
Granting him that because he is ready to pay that when he has conceded to that extent. Whether right or wrong, he is conceded. So you also go a step ahead. Show your benevolence.
Let him approach, consider it.
Little appearance. So Bamdev Baral for the petitioner, Mr. Sanjeev Swai AGA for the 3, 4, and 6, 7. 3, 4, 6, 7. The hard running counsel for the petitioner. It is submitted that the petitioner is agreed by the certificate demand. Demand
page 12.
Page 12.
Demand
page 12.
Annexure 1 minute.
Dated 21/2/2025. Issued by the certificate officer, Sadar Kotak. Issued by the sub-collector, Sadar, certificate officer, Kotak.
Recovery of 27.
In recovery certificate use case number 13 of 2008, into bracket complaint case number 93 of 2007 and 94 of 2007.
For an amount of 27,000.
For an amount of 27,750. It is indicated in the said certificate in the said letter oblique certificate that the petitioner has to pay penalty imposed upon him for non-supply of information under RTI Act. So it is submitted by the learned counsel for the petitioner that the application for providing the information sought for by the OP number 5 was initially rejected. The said opposite party filed fast appeal before the appellate authority. During pendency of the first appeal, the information was provided on Tibet information.
With 22/2/2007 minute. Page 19 minute kind of page 19.
27 to 22/7 like
paragraph 3.
6/3/2007. Page 26 में देखो table है 6/3/2007. The learned counsel for the petitioner also refers to page 25 of the brief, wherein a detailed date chart is provided indicating the sequence adopted by the government in the Department of Panchayat Raj by various officials. It is submitted that supply of information privy to the government under RTI Act is also subject to certain procedure to be followed in the department. You should notice along with this order. The learned AGA, upon advance copy served, appears on behalf of so and so so and so. Mr. Your full name, sir?
Smriti Ranjan Das.
Mr. S.R. Das. Smriti Ranjan Das appears on behalf of the OP number 1. Need two extra copies be served on Mr. Das appearing for the OP number 1.
I will file by Vokalapur.
Mr. Das submits that he has instructions to appear and shall file Vokalatnama within 7 working days.
2 weeks, but
within 2 weeks. Within 2 weeks stop. The learned counsel for the OP number 1 shall obtain instruction. The learned AGA as well as the learned counsel for the OP number 1 shall obtain instruction with regard to no instruction from the opposite parties to regarding waiver of the interest if the petitioner deposits the amount of fine imposed.
So the penalty imposed.
The learned counsels are also assist the court as to whether during pendency of the application, first appeal, the writ petition, that is WPC number 9632/2008, directing stay of directing stay of the demand till 16/5/2023, the authorities can collect the penalty.
Interest on the penalty.
Can collect interest on penalty as well as interest on penalty. On consent return, Mr. Das.
After reopening, madam.
Reopening to definite.
Right. The repeat copy will serve.
Already directed. Be careful in listening to the order when I am dictating.
I'm sorry.
I have asked for 2 copies. But I have directed for 2 copies to be served. Till the next date, there shall be no coercive action against the petitioner regarding. Upon kichi deposit karna hai?
Na bhai, darkhat delu se lagna fiti ase. Mu to obili raji thu darkhat delu section de.
Kichi order karantu nahi.
Bhag mat kaibe tu principal deposit kar di. Principal amar deposit kar di. Mailo direct.
Ko apon deposit karibe. Ki apon batar? Principal amount kete?
37,000 jaha thi.
With interest 80,000
huge
amount.
The petitioner shall deposit the amount of penalty. It was 27,000 in form of a demand draft favoring the registered judicial, which shall be kept in credit to the present proceeding before this court in a SDR. Third deposit receipt in a nationalized bank to be renewed from time to time. On 80 deposit
कर दे जे वर्तमान छुट्टी जो मास छुट्टी ओपनिंग दिन कर दे
कहीं ये करियो आपण ओटे रोस्टर रे ऑफिस खोलिबे
within 30 days I will
by the next date को by the next date by next date
और 10 टा से एका 5 टा केस कर दी 5 टा और 2 टा रहि जाई
ସବୁ ଜାଗା ଆପଣଙ୍କ ଅଫିସ ଆପଣ ନିଜେ ପିଟିସନ
ସବୁଥିରେ ମତେ ମୁଁ ତ ଗୋଟିଏ ଦେବି ତ ଇନଫର୍ମେସନ ସେ ଗୋଟିଏ କଥା ଯେ ହ୍ୱାଟ ଇଜ ଦ ଷ୍ଟାଟସ ଅଫ ବଣ୍ଡେଡ ଲେବର୍ସ ସେ ତାକୁ 4 ପ୍ରକାର 5 ପ୍ରକାର ମାଗିଛି ମାଗିଛନ୍ତି ମାନେ ପିଟିସନର ଯେ ବାଘାମ୍ବର ମାଗିଛନ୍ତି ସେ 5 ପ୍ରକାର 5ଟା ଇନଫର୍ମେସନ ଆପ୍ଲିକେସନ ଯେନ୍ 5ଟାରେ ଫାଇନ ହେଲା ଗୋଟିଏ କଥା କିନ୍ତୁ 5 ପ୍ରକାର ଜିନିଷ ଆଉ ଉପାୟ କିଛି ନାହିଁ ଦବାକୁ ବାଧ୍ୟ ହେଇସାରିଛି ଆସିବ
ଆପଣ ବି ଇନଫର୍ମେସନ ମାଗନ୍ତୁ ଏଥର ଆପଣ ରିଟାୟାର କରିବେ କି
ଆଜ୍ଞା
ଯେ କିଛି ଇମ୍ପ୍ରୁଭମେଣ୍ଟ ହେଇଛି କି ଯୋଉ ପିଟିସନ ଫଳରେ ବଣ୍ଡେଡ ଲେବର ସେଇଟା ଆପଣ ତାକୁ ଚ୍ୟାଲେଞ୍ଜ କରନ୍ତୁ ବି ଆରଟିଆଇ କମିଶନ ପାଖକୁ ଯାଆନ୍ତୁ ତ ଦେ ରିୟଲାଇଜ what is the reality.
I don't know.
Somebody sympathizing with bonded laborers filing RTA application whether really helps the bonded laborers or 80,000 penalty देने पड़े. Yes. So for item 10 से है.
4 out 10.
10.
I am also obliged by that.
Yes. Okay. 10 Mr. Debaraj Man. By Mr. Suraj Mahanti, Mr. P.V. Balakrishna on behalf of Suraj Mahanti for the petition. On 1/5/2025, following order was passed. Thereafter, on 7/5, following order was passed. On 8/5, the petitioner sought for adjournment. The Lord Counsel for the petitioner sought for adjournment. Today, the matter is mentioned by Mr. Balakrishna on behalf of the Lord Counsel for the petitioner. Seeking adjournment. I'll straight for list on. एक के साथ है. Yes.
Item 6.
6.
देखो यदि क्या आसवे स्कोर करता तो डाक्टर. Yes, next.
Item 11.
Mr. C.K. Tripathi for the petition. Mr. Fresh matter, Mr. Tripathi. Yes.
That a demand will also calculate.
That's not a division bench matter. Single bench matter, stop. You are challenging which order?
That certificate proceeding that is initiated, annexure 8, 7, 8, and 9.
For enforcement of
Land revenue, area land revenue from the.
for enforcement of what? Certificate proceeding is for to be collected as areas of land revenue.
Exactly.
But for what? Demand ta kaun thila? Original demand kaun?
Only for land revenue, area land revenue. That is under challenge.
Area land revenue not paid by the department.
Yes.
To pay.
No, that is.
So when you are style of the Jew,
Again, I'm submitting.
you are disconnecting. Have you not disconnected any connection during summer? So if you say that, then I will immediately stay this demand. Then for the room temperature, have you measured? What is the room temperature?
Room with 36-37
Exactly. In the first floor, where I stay, it shows 36, 37. Morning it is 33.
Then normally we are not discounting power supply unless I paid the.
So exactly. Normally they don't issue certificate.
No, that is.
Unless whenever a person, a cash-rich person like Tata Power doesn't pay land revenue.
No, that is as per the vesting Gadawari Lordship. We are paying the premium of ₹1.
Sir, you are talking to your discussions with vesting order with your predecessor. Does it concern the revenue authority? Are they party to your vesting order? Find out that. That would be the best argument you can make.
That we
That the land the revenue authorities or sub collector or collector or tahsildar are party to that vesting agreement between Tata Power and the predecessors.
but pursuant to your lordship's direction, this new direction, a meeting was convened at the chairmanship of the chief secretary. That was decided.
Talk about the result. Who participated by
That revenue, entire revenue system, lordship.
No.
Annex 5.
No. Whether you see, that has obliterated the statute. That discussion by the chief secretary and so many persons, important persons, has obliterated the demand of statute as per the. You see, this is a collection as per the Land Revenue Act, whatever act is there.
Yes.
So what is the impact of that? Is there any discussion?
Yes. That is discussion.
Straight away come to that line.
Yes.
Paragraph.
Annex 5, lordship.
Page, sir.
Page
and line paragraph.
starting from 95. It start from 95.
Land revenue would not be paid. So where is that?
That your lordship, 97, page 97.
Yes.
The middle paragraph. After detailed deliberation.
It is not visible actually. You have photocopied it in darkness or what? 97?
The middle portion, first, second, third, fourth. After fourth lines. Middle, after deliberation, after detailed deliberation, the following decisions were made.
Yes, sir.
1. All the lands.
Straight away come to the land revenue part.
Milord, that is. So the all the area ground
not
rent.
liable to pay any land revenue to the government.
Yes. All the area ground rent, cess, premium, penalty or interest extra claimed on the distribution companies and OPTCL on those lands may be waived.
Maybe wait, no, shall be wait, maybe wait, how is it binding on the court? So obviously,
that is shall be. The reason is that the reason is for waiving of that land revenue because of a portion to that this is the decision.
Important part
the first paragraph 1, your lordship.
Para 2 second line.
All the areas. All the areas.
Second line. Apar ta sheda padila pare ta pora line ta important ta chhad deije.
Yes. A proposal was placed before the cabinet for consideration.
Placed up B ta kiye padibo? Por badhiya porjento.
I'm reading from the beginning, lordship, little bit.
Struggling,
a proposal be placed.
B.
So
it is yet to happen. So then you saw that proposal was placed and the government did it.
That has been done, your lords. That has been done.
So it, sir. That has been done. What is that?
A proposal.
I don't say that I participated in the meeting, so I know it. So you show that was done by the government by placing in the cabinet. Sir, have you ever seen that any kind of land revenue collection? You have any experience of in villages? How? What is the style of
paying the rent? The revenue inspector's office.
petitioner. And otherwise also you will find that at least in the last 50 years I have seen that so many places in the town they have encroached. There are no transformer. Heard learned counsel for the petitioner. The petitioner is agreed by the certificate demand. You dekhan to seta?
There is demand, your lordship, annexure 8 page 103. 85,300.
Certificate demand issued by the certificate officer come Tahsildar Nuapada in certificate case number 1 of 2024. By order dated 12/12/2024, the certificate officer has issued notice under section 6 of OPDR Act 1963 to certificate data. The learned counsel brings to the notice of refers to the conduct.
That is
vesting
the
order.
That is the vesting order and the decision taken pursuant to your lordship. Annexure. That vesting order is annexure. Page Miller annexure 4 vesting order. Page 95 paragraph 56.
Vesting order ta page 93 aramb hochi.
It is very voluminous. Only the relevant paragraph page I have.
Refers to the vesting order passed by the Odisha Electricity Regulatory Commission. Dated?
That is the Miller.
Dated 17/12/2020.
Miller. Date of order is
28/12/2020.
28/12/2020.
Order dated 28/12/2020. तो नहीं किसी तापर
तब ये वॉल्यूम नसी 100 पेज कोंडे अछि बोले रेलेवेंट पेज ता दिस
नहीं 95 टा कोन आपण रेलेवेंट पेज टा कोड पाउचंती
ए अपलोड इट इज अवेलेबल इन द नेट ऑन डाउनलोडिंग वेयर
अरे कोन बेले बेले आज कोन हेची बुझ पर कोन 96 टा वेस्टिंग ऑर्डर रो गोटे पार्ट ना कोठी सेटा आनिले
यस यस
he submits that part of the vesting order is it cannot be because it is the first line is minutes of meeting.
No annexure
Don't make a wrong submission so that the court ends up passing a wrong order.
Different from the
Court to vesting order to submit that. Petitioners rely on the vesting order. Land vesting order to submit that, to contain that provision, to contain that they are not liable to pay any land revenue. They are not liable to any land revenue. Stop. Para. The learned counsel refers to the minutes of meeting held on 20/2021. Into bracket the annexure marking है नहीं.
Annexure 5 minutes.
Page 96, Annexure 5.
Page 95.
Annexure 5, minutes of the meeting dated 9/27. Under the chairmanship of the chief secretary to the government. Who para refer kale para 2.
Para 2.
Para 2 seta no.
Page 97, para 2.
He refers to paragraph 2 captioned as quote. Likhibe page 97 re achi. After detailed deliberation, the following decisions were made. Quote लिखिनेला तापरे जो cross छाड़ी देबे leave blank तीनटा cross देख तापरे 2 all areas of ground rent says so and so up to cabinet for consideration. Para. On being asked, the learned counsel for the petitioner submits that he has to obtain instruction whether the government in the cabinet has taken a decision pursuant to the said proposal as indicated above. Issue notice along with this order. The learned DGA upon advance copy served appears and waives notice on behalf of the opposite party. He supports the demand of land revenue. Submits that the petitioners are liable to pay the land revenue like any other citizen. Para. The learned counsel for the petitioner has adjournment. Has adjournment to obtain instruction. Date कर दियो
9/7.
As prayed for Mr. 9/7/2025, the learned DGA shall obtain instructions from the opposite parties. IA 7229 of 2025. Issue the learned counsel for the petitioner reiterates his submissions as noted above. Issue notice. The learned DGA appears on advance copy served and waives notice. Record karibe.
Of course.
The further proceeding in kete ko case ta seta
1 of 2024.
Page author dekhantu.
Other proceeding.
अरे से जो notice page ta देखिए ना
yes.
कौन आदमी struggle करते
That page 103.
The further proceeding in certificate case number 01 of 2024 shall remain state till the कितने तारीख को बोले
9/7.
9/7 till 15/7 till 15/7 2025 reported to mention before the assigned bench. Mention for listing before the assigned bench.
Obliged.
As an interim measure, it is directed. As an interim measure, it is directed that. Yes.
In this case, my query is target to annex the OR, certificate case, my lord. Certificate case number 29 of 2024, my lord, which is pending before the open number OR.
Target kariye pe kuch. Is it the only case? Is it your government and oath that is the only case pending before the authority? Only case where you have stated that the authority is sitting over only one matter that is pending before.
Then my case is pending.
It will be. How can it be given priority? And much less by the writ court. All the cases are obviously important. So the court cannot direct prioritizing a case.
24.
Discriminatory order.
Also, kind direction. Direct.
Being kind is one thing, but doing justice is another thing also. Very important.
This is the case of
only being kind and not being, not being just and proper is also not correct. Somebody coming to the High Court and seeking a direction to prioritize his case, that can happen only if there is only one case. So you show that there is only one case pending, so he is not taking it up.
This is the case of 2018, my lord.
2018 or 2008, that's not the point.
2018,
it may be 2008 also. Kindly answer the court's query. When you are seeking prioritization On what basis the court can direct prioritization of your case? Kindness and sympathy, very good. I may be more sympathetic and more kind than you, but can I direct? Can that be judicial order?
More than
Which case is
more
pending?
than nine months are already passed. I think.
Which case is pending? Page tag asunti. Who page re achu seda?
Arising out of consumer case. City case number 115 of 2016.
How do you know that the order is not under challenge? Have you heard that?
My lord,
The order passed by the consumer court has been challenged at its finality. Have you stated in your writ petition? Apana,
I am the decree holder, my lord.
eh?
I am the decree holder.
Decree has been challenged or not? Court election.
It has not been challenged.
This High Court is not a execution proceeding.
Education case has already been filed, my lord. Thereafter, a letter issued by the District Consumer Forum to the collector.
Who is the letter?
My lord, I have quoted my I have already quoted my lord.
Quote କରନ୍ତୁନି କାଗଜ ଦେଖାନ୍ତୁ କୋଉ କାଗଜରେ ଆପଣଙ୍କର ବିକ୍ରି ହେଲା କୋଉ କାଗଜରେ ଆପଣ ବିକ୍ରି ପାଇଁ ଏକ୍ଜିକ୍ୟୁସନ ପାଇଁ ଗଲା उल्टेले add हवनी कागज उल्टेले I have the advantage of looking at the entire papers.
Let it come after vacation.
Or after vacation कौन
I have available this paper, my lord.
that should ଆପଣଙ୍କର ଯଦି କିଛି case ଅଛି should bring to the court. The learned counsel for the petitioner ସେଠି move କରିକି ସେଟାକୁ ସେ କହନ୍ତୁ ସେ he will pass a order. The learned counsel for the petitioner hard counsel for the ଆପଣଙ୍କ ନାମ ହେଉଛି Mr. Pavitra Kumar Behera. Mr. Pavitra Kumar Behera for the petitioner. Mr. Devaraj Mahanti AGA for the state. Learned counsel for the petitioner, hard learned counsel for the petitioner. The prayer in the petition is to target the certificate case number 29 of 2024, pending before TOPI number 1. Para. He submitted that the petitioner is having a order in his favor passed by court lekile.
Passed by the District Consumer.
Passed by the District Consumer Forum.
Forum
Bhubaneswar in
city case number 115
case number 115 of 2016. Dated
22/5/2018.
अब ଏବେ
22/5/2018.
And that is allowed ex parte order.
Ex parte order.
Ex parte order, how it will be enforced? How do you know that? Or like Bhubaneswar dated 22/5/2018, past tense so and so, so and so. As averred in the writ petition, the said order was passed ex parte against the present opposite party. Number two, the learned counsel for the petitioner was asked whether the state order has been challenged or any other order has been passed. The learned counsel submits that he has no further instructions regarding whether the order has been challenged or not.
That order has not been challenged.
How do you know that, sir? That where you have averred, straight away come to that averment on oath where you have stated it. You see, my time is also valuable. Though I am assisting you, that doesn't mean that I will go on like do like this. Where you have stated in your petition that it has not been challenged at in finality, and it's ex parte order.
Ex parte order.
So show that. Again, sir, turning of pages. You see, we have now a limitation also. Even if I do not dictate that you are turning pages, it is seen by so many people. No further instruction. as it has not been stated in the petition. The Lord AG in response submits that the execution case was filed in the year 2024 and it cannot be said that the matter has been delayed. Having heard the learned counsel for the parties, please observe that if the petitioner is so advised and move the opposite party number 1 authority, that is Special Certificate Officer cum Sub Collector Bhubaneswar, for expediting the matter. If any such application is made, the same shall be considered in its own merit and the order shall be passed. Writ petition is disposed of. Para, it is clarified that this court has not expressed any opinion regarding merits of the case or contentions of the parties in any manner. Yes. City move karo the application degi chahe kariye. And please develop a habit of being
In Lordship, item 13, your Lordship kindly permit to withdraw.
Your name, sir?
Ambika Vallabh Malik.
Mr. A.B. Malik for the petitioner, Mr. Devaraj Mahanti, AGA for the state. The memo of withdrawal signed by you. You have signed. The Mr. Mishra has signed.
I am signing.
The bracket is upon now. He submitted that the petitioner wants to withdraw the writ petition. Memo of date filed in court, taken on record. The writ petition is disposed of.
Pardon, my lord, I'm in BC, item number 6, due to some technical problem, I cannot reach, my lord. On behalf of my lord, Mr. B.S. Mishra, my lord, I am praying for an adjournment, my lord.
Ashok.
The record of the item 6 left to. Item 6, Mr. Vijit Mahanti. You are for? Item 6.
No, sorry, my lord. Bhul rahe ho technical.
Mr. Vijit Mahanti on behalf of Bhubaneswar Mishra for the petitioner. Mr. Sanjeev Swai EGA for the state. Learned counsel Mr. Mahanti appears in BC on behalf of the learned counsel for the petitioner. 6 adjournment. As prayed for list on.
Dui saath.
Obliged, my lord.
Yes, please. Next, call Karantu.
Patel.
Petitioner blank. Opposite party. Mr. Devaraj Mahanti, AGA. List on. Date Karantu. Irish.
15. May I please, Your Lordship?
Mr. Ghanshyam Namtowar for the petitioner. Mr. Ambika Prasad Rai for the opposite party. Yes, Mr. Namtowar.
Yes, Lord. Item 15. May I please, Your Lordship? Here, the petitioner is a professional educational institution, Lord, which is dealing with professional courses of learning and giving training to very few and there are very few numbers of staffs in the educational center, my lord.
Yes.
It is not covered within the meaning of ESI, that is Employee State Insurance Corporation, my lord, because Section 212 of the ESI Act 1948 clearly defines factory, which means that there should be more than 10 or more persons which are employed there. So, thus, according to the standard note of ESI scheme, as on 1/1/2011, educational institution employed 20 or more persons in Odisha is to be covered, but the revised standard ESI scheme on 12/1/2005 has reduced to the coverage of 20 from 20 to 10%. Your Lordship may see my coverage in Annexure 4. Annexure 4, your Lordship may see.
Yes, Mr.
Annexure 4 series, I have given my staffing pattern of 2014 and 2025, my lord, which is only 9%. So it is not coming within that purview of the standard pattern, my lord, which is less than 10. But here, under Annexure 6, they've issued a letter that you have to immediately deposit 18,68,759 rupees immediately, or that will be taken action. So my respectful submission is, my lord, when it is not coming within that period purview of ESI, so I apply.
But Mr. Namto, it's a beneficial legislation. It has a social objective also.
It may be, my lord, but if I have not covered within that ESI,
you are referring to which section?
I am referring to section 212. At present, it is amended that it should reduce that factory. That the definition of factory will be reduced from 20 to 10.
So.
Earlier it was 20, then it was reduced to 10% that it will coming under that purview.
Is there any order where they say that you are a factory under section 212?
They are directly demanding, Lord, in Annexure 6, your Lordship may see.
I may be permitted, my lord.
Yes,
educational institution means it should be covered under section 15, my lord, not under section 212.
15, 15. You are saying 15.
One subsection
1/5, subclause 5.
My lord. And for this, there is gazette notification issued by the government of Odisha, my lord.
Is there a book on states, government of Odisha rules?
My lord?
ESI rule state ro
government of Odisha is the act empowers the appropriate.
Correct. No, in fact, I was asking just when Mr. Namtuar was submitting. Coincidentally, I was asking the court master. See publication से बहिटा मानू की रखुं.
ए बहिरे भी ये कोर्ट माने डिस्ट्रिक्ट जो प्रोसीडिंग होउची तार रूल्स फुल सब ये बहिरे रही छी.
Is published by
नंबर ओएल नहीं इट जो दी लॉ educational institution must be covered on the system.
Mr. Namtuar, you see this notification entry 717. से पॉइंट आनो देखिए लाइब्रेरी रे गोटे कॉपी कोर्ट रे गोटे कॉपी आगे स्पीकर कॉपी तो रखिबे
and that is provision under section 75 to approve the statutory forum for redressal of the grievance.
Let's come out of
and the other part. Now the difficult part would be, perhaps most difficult part is that the read court cannot adjudicate that aspect. The ESI court, district judge, you have to go there and 75. Look at 75, please. Boy, अच्छी है सही तरह अच्छी. Regarding interpretation of 1/5 notification and 2/5.
Yes.
1/5 and 2/9 बजे ना कितने
1/5 and 2/12 my lord.
2/12. So the interplay of 1/5 and 2/12 is a factual.
Then you're also directed to LE before the district judge.
देखी दियो तो. No, I am not. Because I don't believe in that.
Because in
you'll be in a
Jharsuguda,
hurry and you'll be in a hurry and I will
one problem is there, my lord. In Jharsuguda, the district judge is not entertaining this case. That we have not such cases.
No, no, how?
Notify Draupadi Institute করতেলি accept করনাନ୍ତି পুরা.
There is a notification of the
statutory notification is there.
my lord.
And in fact, some orders are of the district, the ESI court is under challenge also.
Yes, yes.
Before the High Court also.
Yes, please.
Right? Constitutional of Employees Insurance Code under section 74 and matters to be decided by the Employees Insurance Code under section 75.
And Odisha rules. Odisha rules
the Employees Insurance Code, Employees Insurance Code rules 1951 is also there. All the procedural aspect.
Mr. Ray, some courts have been, areas have been combined or each district is having a ESI court?
For each district, the district judges are empowered to enter them. Only in
it is Jharsuguda.
Sundargarh, there is two EI courts, one at Sundargarh and one at Raulkala.
That's a huge industrial belt.
My lord.
Still, I think it can, because the statute provides there can be more than one also.
My lord.
The state government can appoint two or more courts for the same local area. 74-4.
My lord.
That can be.
The Lordship, the director the matter to be alleged before the district judge Jharsuguda, I think. That is it.
So, the Lord, Mr. Appearance section. Napon documents. Mr. Ghanshyam Namtowar for the petitioner. Mr. Ambika Prasad Ray for the opposite party. Hard running country for the petitioner. He submitted that the petitioner institution would not be a factory as defined under the PSI Act, 1948, section 2 into bracket English 12. It is submitted that the demand notice,
again, Annexure 6.
Focus. The focus notice dated 7/3/2025 to bracket Annexure 5, issued by the Office of the Recovery Officer, ESI Corporation, Jharsuguda. Focus notice देखले, and the demand notice.
এটা 24/3/2025 এর করতে লাগে।
And the demand notice under section. এটা attachment দিয়েছি
না এই attachment করনা তো I noticed
কপিটা দেই না তো ডিফিকাল্টিজ হচ্ছে I am unable to place
ঠিক ଆପଣ ଟିକେ মিস্টার রিড কপিটা ଟିକେ মিস্টার রাইট করে দিন ঠিক আছে so ray look at page 18 annexure 6 first is page 17 local.
This is my lord attachment order.
That I was asking. On लिख ले sentence का पढ़ो. As well as the attachment notice order rule 48. Garnishee.
No, this is not garnishee. After this,
Because it is referring to 48 of second schedule of Income Tax Act.
my lord, garnishee is under section 45G, my lord.
45G.
My lord.
Of ESI Act.
ESI Act.
On लिख ले. Attachment order dated 24/3/2025. To bracket annexer 6. Are without authority of law. Lord, paragraph लिखो तो Mr. Ambika Prasad Ray. I'm sorry, Amrendra Prasad Ray, who usually appears for the opposite party corporation, is present. Accepts notice. Para. Mr. Ray in response submits that in view of the specific provision, that is section 1 into bracket 5, the state government has power to notify any institution to be covered by the ESI Act, 1948. Stop. The petitioner institution is an educational institution, is notified by the government to be covered by the ESI Act. The notification dated?
25/10/2011. 25/10/2011.
Notification dated 25/10/2011. At entry, VII.
My lord, that date may be, I will provide the date.
So, date is 11 state government. The Learned Counsel also refers to section 75, 74 and 75 of chapter VI, capital Roman VI of the ESI Act regarding adjudication of dispute and claims. It is submitted that the petitioner has more efficacious remedy as he disputes his the demand on the basis that he is not covered by the ESI Act. The Learned Counsel for the petitioner submits that he shall move the appropriate court for under section 70, section 75. Appropriate employees insurance court. Employees insurance, employees terms ESI for apostolic. Insurance code under section 75. Para. Having heard Learned Counsel for the petitioner, for the parties, the writ petition is disposed of, granting liberty to the petitioner to move the employees insurance code. The writ petition is disposed of.
In the meanwhile, no course of action to take. In the meanwhile, no course.
Madan Gopal room ta 56 Supreme Court. 52. State of Odisha versus Madan Gopal room and disposed of petitions. The Learned Counsel submits that he shall also file petition for seeking interim relief. If the prayer of the petitioner for interim relief before the ESI court shall be considered in accordance with law as expeditiously as possible.
My lord, issue notice. My lord, may I direct the petitioner to serve one copy of the writ petition.
I'll in course of the day.
Copy of the writ petition is served. Since I am disposing of city, that is how I am not issued.
My lord.
Copy of the writ petition is served on the counsel for the project. Next.
60. May I please, Your Lords?
Yes, please.
Sir, here, the petitioners who are before this honorable court for the lowest grade of employment in the ordnance factory at Balangir.
Yes.
From the year 2000,
from the year 1997. And the present writ petitioner is also with the same prayer for a direction to give employment to the petitioner, being because they are local people. Your Lordship kindly see, and the page 4 of my writ petition. Earlier, the present petition number 2 and 3, along with others, had approached this Honorable Court in OJC number 15454 of 1997.
Yes.
Challenging the process of selection because persons, those who are not of the local people, with the connivance of the administration, they were going to be selected. So they had approached this Honorable Court.
Yes.
And while disposing of that said writ petition, the Honorable Court has directed, Your Lordship, I see the order which I have annexed, page 34. The relevant portion is from page 41, paragraph
Yes.
9. It is emphasized that the petitioners have not urged before the individual discrimination. Instead, they have challenged the entire selection process on particular ground. It is argued with a greater emphasis that though the consistent with the earlier commitment, local people of Balangir district would have been given priority as the preference in the matter of employment. Here, what happened, my lord, your lordship knows, there are 3 districts, Balangir, Kalahandi, and Korapur. Way back in 1960s, 70s, it was considered to be the most backward district of the country. That is why it was shortly termed to be KBK districts. And for special emphasis, a committee was constituted. That is all your lordship knows, in our country almost 90% is only on paper. They did it. But incidentally, when Mrs. Gandhi was the Prime Minister, she gave declared and opened an ordnance factory at Balangir. And there it was promised that the local people will be given employment in the suitable post. Local people means those who are they are categorized, those who are lands were ousted, those though they did not have land, but they are local people. All these people will be considered to be local people. So accordingly, employment this generated. What happened generally, the so-called the intelligent people other than the KBK area, because that is a backward area, so the rest area is better intelligent. What they did, in the higher post people were having, they brought their relatives and friends and obtained a false residential certificate. That can't be strictly said to be false. But because you also know the residence certificate is given if a person who is staying at more than 2 years in a place. Resident is not a local one. Local one means minimum, if not if not the forefathers, at least he is born in the local area. In that area.
Yes.
So, local area is to be examined in a different manner. So accordingly, this matter was heard as back as in the Lord on your lordship, as you see the operative portion of the judgment. It was decided on 11th August 1998. The way the system goes very slow, they are almost in most of them 1 or 2 have died.
You are at which page?
43.
Page 43.
The 44, your lordship, sorry, 42 relevant page, paragraph 11. This Honorable Court directed, your lordship got it, paragraph 11.
Just a second. There are so many similar pages, so that is how it is.
It is unfortunate, my lord, there is a saying, Garibo hoiki janma howata papo, Garibo hoiki janma howata Balangir mahapapo. Because there nobody listens, nobody.
You are referring to page 46.
42, my lord.
42.
My lord.
Paragraph 11, my lord, that opposite part of the...
Yes, considering all the aspects of the case.
Yes, my lord.
And submission of the learned lawyer of the resolved parties, we are of the considered view that generally speaking, the selection process does not suffer from any infirmity. If there were found representation practiced by the candidates of obtaining false residential certificate to obtain employment, their cases should be considered by the appropriate authority in accordance with the law. Opportunity is given to the petitioners to point out the names of the selected candidates individuals who are admittedly outsiders and who are alleged to have been obtained employment by producing false residential certificates, suppression of facts, misrepresentation, and collector, along with the general manager of the ordnance factory, will jointly make inquiry to such allegations made by the writ petition within a reasonable time. And that reasonable time is not yet reached. It is the order passed on 1998. And from this plea or that plea, the State Council or the Council for the Ordinance, your Lordship, I see the voluminous orders, they are all vexed. And in this process, they are almost going to attend the superannuation period. And the man with the administration, your Lordship knows, these people are who are the general public harassed by means by the functionaries of the state. With all respect, this is what I am not telling. Great people have said, like Rajgopalachari. So here, instead of these people had appeared, they were selected, but they were not appointed because they were in the lower in the merit list. And after 98, in the process, now they have issued an advertisement, which is I have annexed as Annexure 10, inviting application for contractual post for that lowest category. This is the
Annexure 10. 10 you find that?
This is IA number 8350. The present miscase for which I have filed for stay.
Annexure 10, yes.
Yeah. Even the lowest category, my lord, this is a laborer. The people who are selected and waiting, they are local people, they are not able to do. And in the inquiry they have given, and as per their slipshod inquiry, slipshod I will say, they have found 18 to 19 people have forced.
You have applied for Annexure 10.
Yes, I have applied for stay Annexure 10.
So, and are you applicant? Are you interested to work?
No, applicant no idea. The applicant have no idea. The whole point is that they are going to appoint we are not in the age. Your Lordship, I see what are the age of the petition.
Yes, Marana, you take notice.
My lord, your Lordship,
IA number 8350 of 2025.
My lord, your Lordship, for a moment, that your Lordship question that I filed this petition in 2018 for a prayer to direct to give employment.
No, I'm not asking you. I wanted to record whether you have applied for this Annexure 10.
That's what I'm answering. I am answering. I cannot apply. The whole point is that your Lordship, I filed the petition in 2018.
Fair enough. No issues there, because if you sorry, if you have applied,
I had applied in earlier and I was selected long back. I am in the select list, and they can very well give employment in a contractual manner to the person who are the petitioners. And instead of that, they have issued this advertisement for inviting application, full advertisement notification page, that is Annexure 10 to my miscase. So here they have applied for contractual, and your Lordship, I see online application invited from citizen of India. Your Lordship, I see these were meant for local people. This is the lowest category. Also, they will bring it from Kashmir to Kanyakumari. Where these people will go? What was the use of commitment by the government?
The petitioner.
There shall not be any restriction so far as the appointment is concerned, my lord. As my lord, I am humbly differentiate what my lord senior is submitting. At that point of time, that has been considered, and so far as we have specific given affidavit.
At that point of time,
those who are the land outshifted 1,000.
Let us confine to the IA now.
Yes, ma'am.
IA 8350
From that point of time, we have been pursuing, and by pursuing, we have some of us are dead, and some of us are going to retire because the matter are not disposed of. From this plea or that plea, the entire order sheet will speak for itself.
Just a second.
Labor
just give me a movement. I'm just dictating it. By the petitioner in the writ petition. By petition dated 12/5/2025 by IA by supported by affidavit dated 12/5/2025. The prayer made in the IA is to stay operation of the advertisement of notification under Annexure 10.
Yes, ma'am.
Annexed to the IA, stop. The notification is dated. Apparently, just Mr. V. Maharana, you are senior panel counsel.
Yes, my lord.
Mr. B. Maharana, Senior Panel Counsel for the opposite party.
OP number 3 to 5.
Three to five.
State is also there.
3 to 5 for state.
State protected.
Mr. Rajdeep Pradhan, Additional Standing Judge.
For 1 to 1, 6.
1, 2, and 6 state. Mr. Maharana for 3, 5.
3 to 5. 3, 4, 5.
3, 4, and 5. Stop. The notification is dated.
No, they have not given any date, madam.
Petition.
They have not given any date. The petitioners launched it on 3rd May. I have given the advertisement, you will also see.
This advertisement, this notification I sent to the employment exchange that will be published. Thereafter, my lord, the application will be shut for.
Notification is it's a number achieved.
Number is there on top.
Number 1002. Likhi. Page 10. Page 6 unacceptable.
Yes, number 1002 tenure DBW.
Plus tenure plus DBW slash DBW slash PER into bracket RC slash OFBL slash 2025. It is submitted by the Land Council for the petitioner.
Petitioners, my large number.
The said advertisement indicates that the offline applications are invited from the citizen of India, fulfilling the requisite qualification criteria against the vacancies of the tenure-based TBW into bracket danger building worker on contract basis for to work in the ordnance factory Bodmal, Odisha, initially for a period of 1 year, which may be extended up to a maximum period of 4 years from the date of engagement into bracket including initial period based on factory requirement and individual performance. Stop. It is submitted that the petitioners are local. Petitioner is a local resident.
Our man, the large number.
The petitioner in the IA is a local resident. Along with the other petitioners in the writ petition are local residents. They have not applied for the. They have not applied or did not intend to apply for the said notification for dangerous building worker on contract basis for 1 year.
Then we are not
but they are
eligible.
Agreed by the condition.
Our age is not there eligible. We are on the verge of retirement age.
But they are agreed by the condition of imposition of the condition that everyone can apply, whereas the employment of the contractual workers as tenure-based DBW should be confined to the local persons. Local persons of Balangir.
Yes.
Local persons of district of Balangir. Para. Upon a copy by Mr. Maharana, learned counsel, learned senior panel counsel appearing for the opposite party, so and so, submits that he has received copy of the IA and may be accommodated to obtain instruction. Para. Mr. Maharana makes a prima facie submission that preliminary submission. That's a preliminary submission that the employment in the ordnance factory at Bodmal cannot be confined to the local area, and it being kept open for all citizens of India is the correct procedure adopted by the authority. Para. Issue notice along with this order. Since Mr. Maharana and Mr. AC have already appeared, no further notice be issued. The opposite parties shall file their counter. In the interim, it is directed that the appointments made pursuant to the advertisement number 1002/10 পুরোটা লিখিবে সেটা যেমতি লেখা আছে so and so as per annexure 10 shall continue but shall be subject to the further orders to be passed by this court. ଗୋଟେ ডেট কর দিয়ন্তু আচ্ছা আচ্ছা এটা আগে লিখবে though the matter was adjourned to be taken up. First opening sentence. So the matter is adjourned to be taken up on 3/7/2025 by order dated dash by order dated dash passed by this court by coordinate bench
By this
by this bench by order dated 2/5/2025. The matter is listed being mentioned by the learned counsel for the petitioner. Listed today. Being mentioned by the learned counsel for the petitioner for taking up of the IA. order ta korle. List on 3/7 as directed earlier.
But till that there shall not be any appointment, man.
The appointment will be made
with all respect, then it will petition become infructuous. It will go by
1 year. For 1 year, I cannot. I do not know whether they dangerous building worker. I cannot stay.
Beloved, your lordship can stay. Your lordship can stay.
Yes.
Your
can.
Your lordship can hear. Your lordship may hear me for a moment. Your lordship may hear me for a moment.
The Lord counsel for the petitioner submits that.
Your lordship may hear me for a moment.
Yes. I'm recording your submission.
But then your lordship may hear me for a moment.
Yes, I will continue to hear, but let me complete the order. Since I have already completed, so I'll miss the track. The learned counsel for the petitioner insists for stay. Submits that order should be passed for making no appointment pursuant to the advertisement.
Selection, but they shall not make any appointment without leave of the court.
Annexure 10.
Beloved, they let them proceed with the selection, but let them not appoint without leave of the court. Because
no, they will proceed, but subject to result.
No, not
yes, subject to further.
Beloved, your lordship may dismiss the writ petition. आप किसी नहीं writ petition किसी ରହିବନି. आगे
correct.
2018
Let me record it, sir. Sir, I have to pass that order. Please, let me record
your lordship may pass that order, but your lordship may, after hearing me, should pass order. My point is that by passing that order, the process it is being taken in last all orders. They will be appointed, and our age is now 45, 55, 6, 47, 52,
58. Yes.
It is amounts to dismissal of the writ petition.
The petitioners have crossed the age of appointment.
Then they proceed their
writ petition.
Your lordship can hear me. Your lord
and almost approve the age of superannuation.
Yes. आज ସେମାନେ appointment ପାଇବେ ଆଇ जो our process of hearing होची it will take another 10 years to be disposed of. So the whole
could be that. Yes.
ଆଜ୍ଞା ଏଟା 2097 98 ଉପରେ ଆମେ ଚାକିରି ଦିଅ ବୋଲି କହୁଛୁ. This is the second round, and second round ରେ inquiry କର ବୋଲି.
No, this is only for the contingency of. It is very clear tenure based dangerous building work.
Why they can't give us the person who are selected? Why they can't give us the petitioners who are selected? We are selected.
Have you made an application for to be selected? Because you said you not apply. No, for this tenure based application dangerous building worker. Dangerous building worker.
Yes, we have applied and we are selected. We had applied
for dangerous building worker.
Yes, we had applied, we are selected.
Submitted by the learned counsel for the petitioner that they had applied to be engaged as tenure-based dangerous building worker. They applied.
My lord,
your lordship can see.
Yes.
My lord, yes. Complete sentence no shonle don't बुझी हबनी आज्ञा.
More limitation नहीं. More बुझिबार limitation थिबो सेतरी किछ नहीं. I don't boast of my competence.
आज्ञा आपण बोस्ट करबे कॉम्पिटेंस नहीं. मु कहबी मोर बोस्ट करबे कंपटीशन नहीं. क्लाइंट माने कोर्ट सुप्रीम कोर्ट.
I do not boast of my competence that whether I can understand.
Boast kichu nahi. If we will hear each other patiently, we can understand each other patiently.
You have completed it. Have you finished your submission or not?
No. Before completing my sentence, I am your lordship may hear me till I complete.
Because you submitted, then Mr. Maharana submitted, then I started dictating order.
No. Halfway your lordship wanted to pass the order. I thought that your lordship will direct the operation of the order. But if your lordship will allow them to appointment, then it is better to dismiss the writ petition.
Whether I will dismiss or not, I will record your submission that it is better, but I will not dismiss. Why should I? Because it is an I am taking up. I am not taking up the writ petition also.
It amounts to that. If your lordship will allow them to appoint, it will amount to that. We have been fighting from 1997. The court has directed to make an inquiry. They have not inquiry. They are liable for contempt. But the contempt procedure we don't initiate. We don't initiate contempt proceeding. And because they are state authority, because the state authority is much above than the general public. General public is nothing but less than animal. They have been treated as your lordship can see all orders. Here, these petitioners who had applied before 97, they were selected. So because they were in the lower cadre of their requirement at that time, 90, 50, 60 or 70 they required at that time. We are in the below. From that list, they can very well appoint now. Why they will issue an advertisement calling for new candidates? We are already selected. We are going to attain the age of superannuation. And this writ petition has already become infructuous 80%. I guess
Mr. Mishra, these petitioners have been difficult in applying for this thing. They don't want to apply. ସେମାନେ apply କରିଥିଲେ select ହେଇଛନ୍ତି ଏଟା ଫେର ଆଉ ଥରେ apply କରିବେ ବର୍ତ୍ତମାନ 20 ବର୍ଷ ପରେ 30 ବର୍ଷ ପରେ we had applied, we are selected, we are in the select list. So whether the petitioners have applied for the tenure based DBW,
that was regular. The advertisement which was published 20 or 30 years back, that was for regular.
Have you annexed the advertisement in the
that is not disputed. I have stated in my petition. Your lordship can see. In the cost title, your lordship see, I have read the writ petition, your lordship can see. Your lordship can see.
The earlier advertisement where you have applied, is it annexed?
Writ petition, your lordship can see. Select list, I have given page 1 from page 1, your lordship can see. Petition number 1, select list number 70. Petition number 2, select list serial number 155. Number 3, select list 49. These are all selected. I have stated in my petition. Number 4 is serial number 43. Select list. Select list.
Look at the cost title, the petition data, but 3, 4, 5 in favor of the petitioner as dangerous building worker. So they were selected.
Yes, they're all petitioners.
Your lordship, for that reason, the GM has been personal appearance. I have filed affidavit in that respect.
Wait 1 minute.
That including that, 463 persons, the merit list has been prepared. And out of merit list, 172 get the appointment and 17 reserve. In that list, my senior client is not there. And they have challenged that order from the merit, select list.
Look at the writ petition where it is said, select list serial number 70, serial number 155, serial number 349, 46. So
that is the result sheet of 143% has appeared. That result sheet has been published, and subsequently, out of them, 172 appointed as a selection list, and 17 as a reserve. I have filed in the affidavit. Your lordship can see affidavit dated 4/4/2024.
after the vacation case dismiss allow I am also going to die.
So far as the selection list is concerned,
for IA I cannot take up.
No, IA is, you let that be stay, let it be taken up after vacation.
No, I cannot stay dangerous building worker because
I am
trying to understand Mr. Mishra.
Not a dangerous
they
are laborer. They are laborer. Dangerous building worker. They are working in ordinary speed, less laborer. They are laborers.
Yes, Mr. Mishra, don't get agitated. Don't
I'm not
be,
agitating.
be patient. Be patient. I'm asking something to Mr. Maharana, which is in your favor.
My lord.
Mr. Maharana, if you are engaging the persons inviting applications and these persons, they have stated that their serial number, they applied for dangerous building. Look at that. So look at that.
I am just answering. You know, that there is a 463 persons.
Please listen to my question, then you can answer.
Yes.
The question. Look at the read petition first page.
My lord.
So they applied for dangerous building worker.
Yes, madam.
Out of the selection list prepared by the OP number 5.
Yes, madam.
Correct.
Yes.
They have undergone the selection process.
Yes, madam.
They have undergone the selection
Yes,
process.
madam.
So after that, they are put in the selection list. 197, 297, static 70, someone is 49. So what is your response to that?
That part I respectfully submit that out of 463.
Arey sir, don't tell me. Did I ask you that whether how many 463? I am asking you a simple question.
My lord.
So then I have to give you example also. Please concentrate on the Mahendra Tandi, serial number 70. Lalit Kumar Mahananda, serial number 49.
My lord.
Look at the
I'm answering that, my lord. You lordship me.
You are yet to get the question completely, sir. After they have undergone the selection process and kept at the serial list. At a
not the select list. The list has been prepared. In merit list has prepared out of 463 candidates, out of which 172 got appointment.
Sir, that
has been challenged in the read application.
To tell me 2-3 times.
Yes, madam.
You have very well said. I'm with you that I've got you. That after 463, 163 were appointed.
Yes, madam.
But I'm asking you something else. Mahendra Tandi 70, Lalit Mahananda 49. Those are there in the list or not?
Yes, madam.
So they are in the list.
Yes, madam.
So why you have been repeating that? So are they appointed? Mahendra Tandi, Lalit Mahananda, are they appointed?
No, madam.
So if now you are advertising for contractual appointments, what is the difficulty in engaging them?
My lord, this list is in the year of 1997.
Sir,
let me. I am answering, your lordship. This list is in 1997 list. They are one merit list has been prepared. Out of merit list, 463% has been given appointment.
With greatest of respect, neither I am able to communicate with Mr. Mishra nor with you.
My lord,
the question is very specific.
The rights. Let me answer in my way.
Advertisement also. Look at the advertisement and expect it.
Advertisement in respect of current advertisement, connected so far the earlier advertisement in 1997 is concerned, my lord.
Who is saying it is connected? Who says that the earlier advertisement and annexed 10 are connected? Who is saying that? Then you are muted. Nobody is saying that. Sir, don't.
Let me clarify.
You clarify when it is required to be clarified.
The rights.
You look at the advertisement.
You lordship kindly see. Let me clarify. Just 2 minutes time.
Sir, give me a second to listen my question. What is my question to you?
My lord.
What is the question?
That whether they have done the
I asked that. You can see the replay. All of you can see. I asked you to look at the advertisement annexed 10.
Yes, madam.
So look at that.
Yes, madam.
What is, my lord?
That
advertisement is for now. What I remember, I'll tell you. That advertisement is for contractual appointment of dangerous building worker.
Yes, madam.
Yes. So now the next question is that each person, can they be engaged contractually for that particular work?
No, madam. No.
The dangerous building worker. They have. After putting the petitioners had applied as indicated in the writ petition to work as dangerous building worker. They have mentioned their respective serial numbers in the selection list. prepared by the opposite party authorities. He submitted that the advertisement annexed to the IEA marked as Annex 10 is again for the selection of dangerous building worker. Though the same is tenure based or contract basis. The learned counsel for the petitioner submits that unless unless appointment pursuant to the advertisement are stayed by this court, there is no point in pressing the writ petition. Then nothing would remain in the writ petition. In considered opinion of this court, since the advertisement is is very clear to the extent that the vacancies are tenure based and only for 1 year to be extended at the instance of the employer, and the petition is pending since 2018, much before the advertisement. The rights of the petitioner shall be protected as far as the writ petition is concerned, as far as the prayer made in the writ petition is concerned. The learned counsel, Mr. Maharana, appearing for the opposite party, submits that was specifically asked whether the petitioners were selected, petitioner's name finds place in the select list of applicants for dangerous building worker, as stated in the writ petition. Mr. Maharana submits that a list of 463 persons was prepared in the year
1997.
In the year 1997. Out of the said list, 173 persons,
72
persons have been given appointment. The rest of the persons have not been the rest of the persons from serial number 173 till 463 have not been given appointment. But you are not denying that they were part of the selection process. They
are a part of selection process, and that is the subject matter of that writ petition.
Mr. Maharana also clarifies that the petitioner's claim is correct to the extent that they participated in the said selection process and their name finds in the select list.
In the list prepared at the basis of interview and written.
In the list prepared on the basis of interview and
the written examination.
Written test conducted by the opposite parties. I'm being asked Mr. Maharana for the opposite parties whether the petitioners can also be given employment as tenure-based dangerous building worker on contract basis for a year. He submits on instruction that they cannot be given appointment. The learned counsel for the petitioner again reiterates his submission to stay the selection process of the dangerous building worker. Tenure-based danger building worker. Danger building worker on contract basis for 1 year. Pursuant to the advertisement as Annex 10. In considered opinion of this court, since the court is not in a position to determine whether for a important establishment like a ordnance factory where ammunitions are manufactured, the recruitment for contractual tenure-based DBW, if state would impact production of any such ammunition, the prayer for stay of recruitment, stay of advertisement and recruitment pursuant thereto is rejected. However, in view of the stand taken by the opposite parties, it is also directed that the petitioners shall also be considered for the said appointment of tenure-based DBW on contract basis for 1 year, if they are inclined to work as such. The petitioners shall move the opposite.
We are all inclined, my lord. Your lordship may record, we are all inclined. In fact, we are all interested to go on a contractual basis till our decision is made. We are inclined.
Subject to eligibility, my lord. That.
Subject to eligibility was one thing definitely, sir.
I will not.
I don't make mistake, Mr. Mohana, like 173, 164, I remember 463. Then why I am unable to recollect 172 because of this interruption. You are saying, once you are saying that they are not, we cannot give appointment, then you are saying subject to eligibility. I have recorded Mr. Misra's submission that they are not inclined. Now Mr. Misra says they are inclined.
No. I did not say that we cannot apply because our age is not there. That will straightway rejected. Just
a second. I have lost again. I have lost the track.
Our age no apply it is not that being eligible we are not declining. Your lordship may kindly appreciate one thing. We are not eligible because of our age.
For 1 year. If they are
interested to work in the
counsel for the petitioner,
we are all interested.
Submits that,
give us.
Submits that all the petitioners have become now age barred. As age kete achi?
My lord, read petition hela belku.
Annex 10 age barred as the advertised.
18 to 40 years subject to relaxation.
And we are all 40, 18 to 40.
Sorry,
18 to 40 years and subject clause 4, page 7.
But paragraph 4 of the advertisement is 18 to 40 years.
And relaxation is also.
Application with age relaxation as permissible to be given to SC/ST, OBC, NCL, and ex-servicemen candidates. What is NCL?
NCL is non-claimed area.
Yes. NCL, N capital, C capital, L capital. Then for
we are all age but much way above that. Some are 57, some are 45, 55, 52, 58.
Mr. Misra submits that since the petitioners have crossed the age of 40 years, they are not eligible. It's further directed that if the petitioners apply afresh pursuant to the advertisement, petitioners in the writ petition apply afresh pursuant to the advertisement as at Annex 10. In view of the long history of litigation and pendency of the writ petition, if they are age barred, ଆପଣ କୋଉ ଯାଏ ଚାକିରି କରି 50 ବର୍ଷ ଯାଏ
ଆଜ୍ଞା
जो applicant माने जो अछंती they can get themselves engaged for those who are up to 50 years
up to 60 years
60 years they will not retire. How they will
नहीं 60 years पर्यंत काम करि पारबे
no, right now if they want to apply, how much relaxation they will apply
relaxation they should be whatever may be age they will their application should be accepted. आज्ञा मो आमर जते अछि महेंद्र पिटिशन नंबर 1 टा 45 थिला 18 रे
their age but
I mean 40 18 रे 45
or otherwise physically capable of doing the work. physically and medically fit, physically capable, medically fit. Their
Irrespective of their
applications,
age, they should be
their
a-
applications for contractual engagement for 1 year as tenure-based PPW shall be considered, granting them age relaxation. Since considering the nature of work that is indicated in the advertisement,
एक लेबरर आ गया खाली 608
the petitioners have to adhere to the physical standards and medical fitness as would be prescribed for other candidates. Fine. Last date केबे थिला जानिछन?
It will be published in the employment exchange thereafter 30 days, my lord. That has not been published in the employment exchange.
আমার জানলে 21 দিন পর্যন্ত সে 30
You'll also may kindly see.
Submits that, Marana submits that. Annexure 10 has been forwarded to employment exchange, which is to be published and advertised by the employment exchange. Thereafter, published and advertised through the employment exchange.
Yes, man. Para 7, you'll also
for starting the recruitment process.
Para 7.
30 days.
Employment exchange, as per the rules, which is to be published and advertised by the employment exchange.
And that specifies the 30 days from the date of publication of the advertisement in the employment exchange.
It is Mr. Marana further submits that the process of advertisement through the employment exchange has not yet happened, and it may happen in future. In view of such submissions, it is also observed that the petition, if any such advertisement is made, the petitioners, if they are advertised, can make application to be considered in terms of the above order for engagement, for tenure-based danger building worker engagement on contract basis for 1 year. List on 3/7/2025 as directed earlier.
Your Lordship said, Mr. Marana has said that this advertisement is not yet been published by the employment exchange.
Yes, that is his submission.
Is it, Your Lordship, is it saying my instruction is that it is already been published in the employment exchange?
He refers to para 7. He refers to para 7 because I asked that
whether he has got instruction to that or what he is submitting, let him be
No,
clarified.
I have simply recorded it, but maybe you are right or he may be right.
And if it is advertised already, will apply. As per the advertisement, they will consider.
Kindly mark page 8 of your annexure, paragraph 7. That is definitely.
That I have seen.
So obviously, if in fact, if it is in the newspaper or employment news, you would be aware also. That
Yes, that's what
para 7 itself says that it is to go to there and be published.
Yes.
So that has not happened as per his instruction. But your instruction also, you do not refer to any such advertisement. You are simply saying that the letter. This is a letter sent for para 7. Para 7 is clear actually.
Already, if he is saying that it has not yet been
Yes, and in fact, I am not determining that also because I am not myself here.
It's quite right.
Para 7 ta quote kar do. Para 7 page 8 jo Mr. Marana here achi.
Irrespective of age eligibility, they will accept our application now.
Yes, subject to but physical parameters and medical.
Physical, medical. Physically no hala physical, medical set up, but irrespective of the age, they will accept our application.
Yes.
and this matter may be disposed of. The whole point is that एते खेलुचंदी आज्ञा इमान को स्टेट रो फंक्शनरी सहित
contract, you see, IA, it is not a, IA is
contract
only for contractual appointment for 1 year.
order डाकी देले मु जस्ट कहूची
No, actually, Mr. Misra, there would be invitation from the bar. I have crossed the limit. Then second half, I have so many matters still left in the list.
In the meantime, I'll file objection and matter taken up that.
Read petition.
आगे एंता करी तो कर देले 20 वर्ष बीते देले
Maharana, I don't know whether you are arguing the read or the IA.
No, I
So, read is not being taken up. So whatever pleadings are there or not there, it is up to you and petitioner Mr. Misra. As far as IA is concerned, only the interim prayer for stay that has been dealt with by the court. Yeah, that you have heard. So to that extent, the hearing is confined. So nothing beyond that. And a laborer, does he have a choice? To ask this question, a laborer, does he have a choice? He doesn't have a choice.
But that has been already decided by this court in the read petition. That order has been showed by my
kindly show the judgment which says that the laborer has a choice.
No. I am not saying that. I am not saying that.
Once the order is over, let us go to the next matter. Yes.
17.
My lord, the case is the CMPL at section by 23.
Mr. Barik, have you filed that application? We shall continue after recess or we'll finish the list now? What is the opinion of the bar?
My lord, sir, as per honorable court.
ठीक है आपण ଟିକେ ରୁହନ୍ତୁ ଆପଣ ତ ବଢିଆ ଆରାମ ସେ ନୟାଗଡ଼ରେ ଅଛନ୍ତି in AC
My
room.
lord. Yes, my lord.
Yes. Subject is also because the tradition of the bar is that the bench should be there on the last day.
Yes.
So subject and lordship, we can start also slightly delayed also. Maybe half an hour your lordship will finish the order matters or whatever.
So Mr. Barik,
Passover matters.
Mr. Barik, I'll come back after recess.
Because the bar also has to be appointed and we can't.
Yes.
May pardon, item 14.
Passover.
May pardon, item 14 arjan है possible launch पर नहीं item 14 माइल launch पर नहीं
14 टा arjan
नहीं मतलब पास arjan है जाइए launch पर नहीं बेसिक डाटी urgent
फाइल वाला में कौन
माइल नहीं launch पर माइल
There is also a reference. I didn't realize that. I had, in fact, I had to notice actually.
That's it.
So, call करंतु serial के केते पूछंती?
अरे 14 नंबर को
हां 14 मिस्टर महापात्र कोन पूछंती कहले?
My petitioner challenge the order and issue for cancelling the license.
PDS license cancel ହେଇଗଲା?
ମାଇଲା
कोन भलो काम कोन कलर कैंसिल हैला?
without any expiry inquiry जे करी ये कर दे सस्पेंड कर दे तार वैलिडिटी लाइव मार्च 25
PDS रे भलो काम कले इंक्वायरी कोन करियो? माने व्हाट कैन बी द इंक्वायरी? Suppose let us assume, I am giving you example. Pilferage of PDS commodity. कौन इंक्वायरी होगा? So in law school there are exceptions to general exceptions in IPC offences. What is there in theft? Theft रा कौन expense कौन अच्छी? Anyway, the notice
suspension. Suspension and suspension against भी appeal अच्छी appeal जाओ ना
बड़ा कौन entry मॉडल तो ही परियों नहीं it is your choice. That's a good proposition for you. अपना appeal move करिवे Mr. K. Mahapatra for the petitioner, Mr. Devaraj Mahanti, AGA for the state, Advocate Counsel for the petitioner. The petitioner challenges the order of suspension dated 20/8/2024 into bracket annex 4 passed by the sub-collector Kamakhya Nagar, suspending the retail license of the petitioner that is FPS fair price shop retailer of village Garuda Bandi under Bhuvan block. देखिए लिखिए ना for alleged violation of clauses of OPDS Odisha Public Distribution System into bracket control bracket closed order 2016 read with OPDS to bracket control second amendment order 2022. Lord Counsel for the petitioner submits that he shall move the appellate authority under the provisions of the
section 19
section 19 of
OPDS control order.
OPDS control order. So they can rule like it.
I have an space competition.
Authority under para kete kuchunti
19
para 19 of the OPDS into bracket control order 2016. The Lord AGA doesn't object such prayer as the matter is coming for fresh as the matter is listed for fresh admission. The writ petition is disposed of, granting liberty to the petitioner to move the authority under the OPDS control order 2016. Yes.
17.
Mr. Barry.
My lord, I have filed this CMAPL number after 630 of 2023 for restoration of writ petition number 31,427 which was disposed of for non-prosecution.
So that same appeal is the same appeal.
My lord, same.
So if you look at paragraph 2, how it can be condoned? You are saying that the lawyer did not appear, but you say that the petitioner was ill himself.
My lord, time prayed on behalf of the petitioner in the name of the advocate. ଯଦି ମନେକର ସେ ଆଡଭୋକେଟଙ୍କ ନାଁରେ ଟାଇମ୍ ନେଇ ହେବ ନାହିଁ କେବଳ ଆମେ ପକ୍ଷଙ୍କ ନାଁରେ ନା ଟାଇମ୍ଟା ନଉ
ନା ନା ସେମିତି ହେଇପାରିବନି।
ଦେହ ଖରାପ ହେଇଥିଲା ପକ୍ଷ ଆମର ଓକିଲଙ୍କର।
ଆରେ ଆପଣ କଣ ମଦନ ମୋହନ ବିଜୟ ହେଲା ଭଳିଆ କଲେଣି? ଠାକୁର ତ ନିଜେ ଆସିବେନି, ମଦନ ମୋହନ ବିଜୟ ହେବେ, ସେମିତି କଣ ସେଇଟା କଣ ହେଇପାରିବ? And say that specific stand was taken by Mr. Swai. Mr. Swai is today not there. But on the face of it, you have to say something which is to be believed by the court.
ମୁଁ ନିଜର ସାର୍ ଦେହ ଖରାପ ହେଇଥିଲା ବୋଲି ମୁଁ ଆସିପାରିନଥିଲି।
ନାହିଁ ସେଟା କଣ ଆପଣ ଲେଖିଲେ ଯେ once you engage the counsel, you say that I was ill, how can it be the relevant, what relevance it will have?
ନହେଲେ ଗୋଟେ ଲିବର୍ଟି ଦିଅନ୍ତୁ, ମୁଁ ଗୋଟେ ଫାଇଲ କରିଦେବି।
ମୁଁ ଦେଇଥିଲି ଆଜ୍ଞା, ମୁଁ ଆପଣ ଦେଇକି ଲିଷ୍ଟ କରିଥିଲି। You can see the YouTube also.
ମୁଁ ଜାଣିପାରିଲିନି ମାଇ ଲର୍ଡ।
ଆପଣ ପୁରା ହଁ ମାରିଲେ, ବଢିଆ କଲେ। You have this very good ability to take control of the proceeding. That is a very interesting art of a lawyer. The lawyer for the petitioner submits that he shall file six leave to file better application explaining the non-appearance of the learned counsel on कितने तारीख रे ହେଇଥିଲା 28/11/23 रे
28/11/23
अच्छा Mr. Mahanti and Mr. Pradhan, today Mr. Swai is not there, should we take this opportunity to allow his petition?
Lordship may allow to say
yesterday one repetition
allow करे
CM read out what question
the Lordship may allow that petition again
council of the CM लिखो तो is submitted by the learned counsel. Mr. Parik, Mr. Rabindranath Baring be present at the virtual court, High Court of Orissa. I got addresses submit. Is submitted by the learned counsel that due to his illness he could not attend. You are the counsel, sir.
Yes, my lord. Yes,
he could not attend the court when the matter was called. VC appear করছিলেন?
My lord, VC রে।
He could not appear through VC when the matter was called. The writ petition was dismissed for non-prosecution. The learned state counsel takes a fair stand and does not oppose to such prayer of the petitioner. Such prayer of the learned counsel for the petitioner. The same April by 861 of 2023 is allowed. The writ petition stands restored to file. The registry shall do the needful for listing of the matter before the assigned bench. This is the assigned bench.
My lord.
The co matter.
Gaड़ी release by
PDS.
Release of the vehicle. That is when I was filed. I have filed. My lord, the related case was posted to 4/7/2025.
List it is submitted by the learned counsel to the petitioner that connected writ petition WPC number
33,687 of 23.
33,687 of 23 is posted to 4/7.
4/7
33,000 कितने रीट फाइल
ଗତକାଲି ଥିଲା
posted to 4/7. The writ petition on restoration shall also be listed. Writ petition WPC 15824 of 2018 shall also be listed on 4/7. I'm sorry.
31,427.
The writ petition number WPC 31427 of 2023 be listed on 4/7.
Okay. 31427 of 23.
Yes. In
18.
Yes.
I filed this CM appeal for restoration of the writ petition, Your Lordship, that was dismissed.
You are Mr. Patnaik?
Yes, Your Lordship. I have taken the ground that on paragraph 3, Your Lordship.
CM appeal 150 of 2025, Mr. R.P. Patnaik, Ratan Prakash Patnaik for the petitioner. Anyone for the Hydropower Corporation?
Well, in the writ petition 695513,
Yes.
I was appearing. That was twice dismissed by the Honorable Justice.
Twice dismissed?
Yes, yes. Honorable Justice M.S. Hon'Ble. So,
No, the standing order has been changed. The simple dismissal for non-prosecution will be listed before the roster bench.
let's say.
So it did not go to the other bench. So now it has been changed. So the advantage is that the new bench and availability of bench will not be an issue for the petition.
Let's say.
It is only petitioner's entry, more petitioner's entry. But yes, common practice is that it should go to the same bench. Have you served a copy?
No.
CM appeal लिखिले? Get the number CM appeal का?
150.
The 13 I'm sorry, I forgot your name. Upon that author कहले?
Pradeep Kumar Raut, PK Raut.
Mr. Pradeep Kumar Raut for the Pradeep Kumar Raut. इतना तो अपन power not थियो. Because you are culture ना लिखूं तुनी. Order लिखिए.
Other notice may go to the what is the thereafter.
Okay. Issue notice by speed obligated post with heading. You have any difficulty or you can appear?
No, I have not taken any permission. Only just I have instructed that this matter has been listed. That's why I am.
No, I can record that you have instructions and you will file Okalatnama.
Let's.
The learned counsel for the petitioner, hard learned counsel for the petitioner. He refers to the order dismissing the writ petition. Order dated 12/3/2025 dismissing the writ petition WPC number 6955 of 2013. It is stated in the petition at paragraph 3 that the learned counsel appearing for the petitioner met with an accident and he fell down. As he fell down from his two-wheeler on his way to the High Court, after his two-wheeler collided with stray dogs. It is further stated that he was advised, he was provided treatment and advised rest. To notice to the opposite parties, Mr. PK Raut, Pradeep Kumar Raut, who was appearing in the writ petition on behalf of the opposite party corporation, is present in opposite party number 1. One and only for corporation you are appearing?
Only for corporation.
Opposite party number 1 is present in court. Copy देना he submits that though he was appearing in the writ petition, he has not filed any wakalatnama in the present case and may be granted 1 week. How much time? 2 weeks.
2 weeks.
2 weeks time to obtain instruction and file wakalatnama. Mr. AGA से क्या होता है? Mr. Rajdeep Pradhan, additional standard counsel, appears on behalf of the opposite parties 2 and 3. Notice to OP4 issued by registered oblique speed post with 80 requisites for issuance of notice be filed within 5 working days, within 7 working days. 7 working days. Let 2 extra copies of the petition be served on the Law and Additional Standing Council appearing for OP number 2 and 3 during course of the day. The Law and Counsel for the petitioner submits that he has served copy on the Law and Counsel Mr. P.K. Raut in the court today. The date Karantu? Liston 4/7 on consent liston 4/7 2025 the Law and Counsel for the opposite party shall obtain instruction.
Oblige, Your Lordship.
Yes.
19.
Just to lighten your lordship's mood and also the court. So the issue is also related. I'll correlate it with the case matter, my lords. That's why I said.
The only question is that is it that it is I'm looking heavy or the mood is not yet light.
No, my lord, it is not that way. It has never been that way rather. We may have otherwise, my lord, reasons maybe to agree or disagree, but it has never been in the way where it is unpalatable or otherwise, my lord, is like the court bench relationship is never been in question. My lord, if just to continue, I was just asking my friend that should I bring some laughter in the court?
Yes, absolutely.
In relation to this case, if your lordships remember, there used to be a villain called Ajit. Because the new generation may not be knowing. So he told his henchmen.
He was very famous for his dialogues.
So he said, when the hero was caught by him,
double A. Particular double A
25%.
But now the petitioner cannot avail that opportunity because that is for limitation only 60 days. And it is the order of
so then already if you have secured but that amount of how much 26 lakhs
26 lakhs by their own admission.
26 lakhs is not disputed.
No, madam.
And apart from that, the 45A orders have not been communicated to me also. That is my specific averment.
That will,
so
I will answer on that in the rate petition, my lord. Because complete instruction.
As far as interim order is concerned, let us concentrate on that.
My lord.
So you deposit another 5 lakhs.
So then your lordship may grant me some
because to Mr.
to satisfaction of both the states.
To continue that. along with Mr. Asutosh Das for the petitioner. Mr. Asutosh Das.
Yes.
And
Trisha Shreyasi. Trisha Shreyasi.
And Ms. Trisha Shreyasi for the learned counsel and advocate. For the petitioner, Mr. A.K. Rai, senior panel.
A.P. Rai, my lord.
A.P. Rai.
A.K. Rai is
Where is A.K. Rai?
he is for the Union of India.
Yes. Wherever Mr. AP is there, AK should be there. The AP Rai advocate for the OP number 2 and 3. The Learned Senior Counsel refers to the order dated 15/5/2025 to submit that the petitioners need some breathing space, as by freezing their account, they are unable to receive any amount receivable from their principal employer, nor they can satisfy the demand of the
bank guarantee.
Satisfy the the bank guarantee as
The
suggested by the learned
requirement
counsel
of bank. Yes.
Now they can satisfy the requirement of bank guarantee as suggested by the learned counsel, Mr. Ray, for the opposite parties. Alright. On 15/5/2025, order was passed petitioner to provide instruction regarding furnishing of bank guarantee. Having had learned counsel for the petitioner and the learned counsel for the opposite parties 2 and 3, it is directed that the petitioner shall furnish a deposit of 5 lakhs in the name of the registered judicial High Court of Orissa, which shall be invested in a short-term interest-bearing account before a nationalized bank. The learned counsel, the senior counsel, 6 for 4 weeks' time. Accordingly, the said amount shall be deposited within 4 weeks. You will allow it now or after you deposit it?
No, subject to till such time no person or the interim protection shall be subject to such deposit.
The interim protection, then you have to give a date by which you can deposit it. That would be better.
And by 17th of June, subject to lawsuit, sir, because the vacation is there, because we have deposited in the last 4 days will be the Roger vacation, so
Yes,
the officers will also be.
Later, the deposits have been made by 20th of June as undertaken. For the time being, the bank account shall be defrozen by the bank till 23rd June 2025. List on 23rd June 2025, liberty to mention for listing before the assignment.
And one small mistake maybe, or it is because this sense it makes out in para 4 of your lordship's last order.
Yes.
Your lordship have mentioned the learned counsel for the opposite parties, apart from indemnity certificate given by petitioners, shall furnish. Stated that the petitioner shall furnish. That should be added to it. Because otherwise it means they have to furnish the bank guarantee.
Yes, it's a mistake.
It's a more of a typographical.
Yes, but it's an interim order.
It's an interim order. It may not have any say otherwise.
So lengthy orders has the disadvantage of, getting typed over a long process, and at times the shorter orders are better. But for a judge, at times it becomes a
difficult. More so
balance it.
When the matter changes hands, then it becomes a little more difficult. Obliged.
Come back.
20.
Please, my lord.
Yes. So S. Bahadur for the petitioner. Mr. M. Tripathi. Mr. M. Tripathi for the. You are for the, sir?
OP3.
OP3.
In one case. Second case.
First item. So Mr. A.C. Radhi Pradhan for the opposite parties. 1 and 2. For 3 anyone appearing for Bhubaneswar Municipal Corporation?
I am appearing in one case. Second case is
you are 3. Local fund audit, Puri? Acha, Mr. Additional standing also. Mr. Rajdeep Pradhan for OP 1, 2 and 4. Mr. Mitrajit Tripathi for
Only 3 Miller.
3.
Second case is Miller.
What do you want, Mr. Bahadur?
My lord, this case, my
Mitra
lord,
Ranjan Tripathi.
the
You are writing MR Tripathi.
Yes, Miller.
So M.R. Tripathi.
the issue has already been decided, my lord, in another writ application, my lord.
Yes.
This is the copy, my lord.
So you hand over a copy to Mr. Tripathi, let him and Mr. Pradhan.
My lord.
It is submitted by Mr. Bahadur that the issue has been already decided by coordinate bench.
My lord.
By coordinate bench of this court. By judgment dated 3/4/2018 in WPC number 22058 of 2011. Mr. Tripathi undertakes to provide copies of the state judgment to the learned additional standing counsel for the state, as well as Mr. Tripathi appearing for OP number 3. The learned counsel for the opposite parties shall give their response on the next date. List on. And consent list on.
10
7. Second matter में कौन करेंगे?
Other sets of lawyers.
Oh.
Both
so Mr. Sengupta has passed away.
For OP3, learned is in here. Manas Mahapatra appearing for OP3.
That connector lekhan to WPC 17484 of 2011. Petitioner none, opposite party. Rajdeep Pradhan, additional standing counsel for the opposite parties 1 and 2. 1, 2 and 4. 1, 2 and 4. OP3 none. Order lekhan to in view of the order passed in the connected writ petition 30403 of 2011. List on 10/7/2025. Yes.
The copy of the
Copy the same. Okay.
21.
So Bahadur, you serve copies.
My lord,
21 Mr. Adjasiddhi Misra for the petitioner. Anyone for the opposite party? Opposite party के नाम? PSGI, CGC, Senior Panel Counsel. Opposite party none. List on 11/7/20 25.
My lord, may I make a submission? On the last order, my lord, in 13/5/2025, my lord.
Yes.
My lord, another associate have made a mention, my lord.
Yes.
Yeah, there's a typographical error. DK Mishra, he's not DK Mishra, he's DK Mahanti. And the noting sheet.
They have the bulbal DK Mishra file he knew.
DK Mishra ke naam hai, DK Mahanti.
This is submitted by the learned counsel for the petitioner, Mr. Mishra, that the learned associate counsel, his associate counsel's name should be correctly mentioned. The name of the associate counsel is DK Mahanti, not DK Mishra. Registry shall do the needful to correct the name of the learned counsel in the cause list as well as the case brief.
And in the noting, it has been written that the VNAMA has not been filed in the cause list, my lord. We have already filed the VNAMA, my lord.
It is also stated that Wakalatnama has been filed by DK Mahanti.
No, my lord. Siddharath A. Mishra and K. Hussain. That is already.
Wakalatnama on behalf of the petitioner has been filed, and the appearance memo of the learned senior counsel, Mr. K.P. Mishra, has also been filed. The noting regarding the not filing of Wakalatnama or appearance memo shall be treated to be complied with, registry to verify and proceed. Yes.
Watch it.
23.
Lordship, on behalf of Homeland Shakti,
yes,
seeking adjournment.
Please, Mr. Your name?
Amar Mohanty, your lordship.
Amar Mohanty.
Again.
So Amar Mohanty on behalf of A.S. Paul for the petitioner, Ms. Samapika Mishra, for the OMC for the opposite party. The learned counsel for the petitioner seeks adjournment. On consent list on what a date करूँ 30 कर दूँ 30 की सही एक साथ दो साथ second week of third week.
Count is already filed. If you want to file a result in the meantime, you can file.
No, because in his absence.
Unnecessary getting delayed, Your Lordship. He is interested, my lord. It was listed before the local Adalat. So since the compromise is not permissible, so it is listed before Lordship.
On consent list on एक के साथ 20-25 the petitioner shall have the liberty to file rejoinder. The rejoinder will be accepted on the next date upon serving copy thereof on the learned counsel for the petitioner.
For the opposite party.
For the opposite party.
Published.
Yes.
26.
Petitioner, none, Mr. 26, Mr. Sethi, Anshuman Sethi, additional standing counsel for the opposite party.
My lord, in item 26, I am appearing.
Yes.
Before the bank, my lord. My lord, the bank has already been liquidated. And in a similar matter, this order has been passed by your honor.
Mr. Anshuman Sethi for OP number 1 and 2. 1, 2 and 3. Sir, your name, sir?
I am Anup Mishra on behalf of
Anup Mishra.
On behalf of Vector
Mr. Anup Mishra on behalf of Mr. Amyo Kumar Mishra for OP.
For OP4.
The learned counsel for the bank. But that order is not here. You have to file that order in memo. The learned counsel, Mr. Mishra for OP4 files memo of date
17 January 25.
Indicating enclosing the order dated 17/1/2025. The order में para 2 तक para 2. You serve a copy on the adjutant.
My lord, serving.
Peter, ever Peter. These items, Peter.
26.
Copy of the memo is also served on the learned AC. List on what a date got in 16. Yes, next.
28.
My lordships appearing on behalf of the petitioner.
Yes.
Appearing on behalf of Ms. Shalaka Das. The matter may be taken up after vacations, my lordship.
What is your name?
Devika Patnaik.
Miss Devika Patnaik on behalf of Ms. Das. Yes, Shalaka Das for the petitioner. Suman Sethi.
Okay.
For opposite party number 1. Mr. S.N. Mahapatra for the opposite parties 2, 3 and 4. Learned counsel for the petitioner 6 adjournment. List on 16/7/2025.
Obliged to lordships.
Yes. Thank you. And wish you a happy time during the holidays. Enjoyable holiday. Best wishes.
Thank you.
Thank you.